So, good morning, everyone. We are about to start this Cartel Working Group Plenary. The topic for today is opportunities and challenges in the fight against cartels. This session will focus on the use of proactive detection tools to detect cartels and how technology is being used to both assist in detection and the investigation of cartels. It will also consider the challenges presented by new types of infringement, such as price signaling, and new technologies such as algorithms, artificial intelligence, blockchain, and so on. For today, we have a set of distinguished panelists from all around the world, and as we have just 1 hour, I will just welcome you to the session today in this beautiful city, in the Edinburgh, and I will take no longer and introduce our panelists to make their initial remarks. So I will start with Mr. Derek Johnson. He is a commissioner from New Zealand. So Derek, the floor is yours.
Both a pleasure and a privilege to be here in this beautiful city of Edinburgh and to share with you a little of what we've been doing at the New Zealand Commerce Commission in relation to proactive detection of cartels. And I'd like to thank CMA for the opportunity of participating in this session. In New Zealand, we've been working on a data analysis tool for the purpose of screening of bid rigging cartels. We also have an effective whistleblowing tool. But today I would like to share with you 3 other actions that as a commission we've been undertaking more recently. The first of these is that we've been working with the financial crime team at the New Zealand Police, and we've been giving them keywords to test against their investigation database and their investigation materials to see whether there's anything from their investigations that should be referred to us for investigation as cartels. Similarly, we've been working with the New Zealand Customs Service and obtaining data from them in terms of the declared import prices of goods into New Zealand to put that with other data we've got to see whether there's indicia of cartel conduct. The second matter I wanted to mention is the fact we've been, a key focus for us has been developing a human intelligence network. For us, one of our strongest tools for cartel detection is developing and having a strong human intelligence network and having people who will come forward and tell us about cartel activity they hear. We've been finding that takes a long time to develop. We're finding it's taken 2 to 3 years from building those initial relationships until we actually see those come to fruition and getting leads from them. And the final aspect I'd mention is that we've run a media campaign over about 3 years using short videos just highlighting cartel activity as a crime and encouraging people to report it. And we've run that successively twice a year over the last 3 years, and again that's been paying dividends for us. So thank you.
Thank you, Derek. I will now pass the floor to Mrs. Lucilia Falsarella Pereira, Senior Director of Competition Enforcement in the CMA, and to make her initial remarks.
Thank you, Diogo, and good morning, everyone. Firstly, I just want to say I'm really delighted to be part of the panel here today because I think there's so much interesting stuff happening in the fight against cartels at the moment. So talking about proactive detection, this is something the CMA has a long history on, and it's something we regard as a very important part of our toolkit. And as a result of this, for some time now, about half of our cases come from our own detection work as opposed to coming only from leniency. And I like to think about proactive detection activities as falling into 3 categories. Those that have to do with people, those that have to do with organizations, and those that have to do with data. So starting with people, similarly to New Zealand, one of the main sources of information from us are individuals who come to speak to us as informants or as whistleblowers. We have had now a successful informant rewards program for quite some time, and recently we increased the maximum amount we pay to informants to £250,000. And that reflects the fact that we consider this to be a really useful tool in our toolkit. But we don't just waiting for people to come to speak to us. We've been working to develop leads by focusing on specific sectors, and we have carried out some targeted outreach work to people involved in those sectors. Now, moving on to organizations, we've been increasingly working with organizations who may have been victims of cartels, both in the public and in the private sector, so encouraging them to come and speak to us. In the public sector, we work very closely with public procurers, helping them design procurement processes in a way that reduces the risk of collusion, and training officials to spot suspicious red flags. And we have to date reached over 80,000 public sector officials in the UK, which is now resulting in a growing number of approaches to the CMA regarding suspected bid rigging. But we are also very open to working with intelligence received from the private sector as well, so victims in the private sector, ensuring that businesses are not hampered by anti-competitive activity in their ability to grow their businesses and invest. And this is a message that we've been saying loud and clear whenever we are out speaking to the business community in the UK. And finally, turning to data, so my teams in competition enforcement, they are working very closely with data scientists and AI expert colleagues in the CMA to build intelligence and develop leads. So, for example, by using data science capability to screen for cartels using public source data. And we think that using the right tools and with access to the right data, we can increase the detection of cartels, potentially unlocking considerable productivity gains and public sector savings for the benefit of UK taxpayers. Now, all of that proactive detection work is not at all to diminish the importance of leniency, which is obviously still a critical tool in cartel enforcement and, in my view, will always be. And indeed, we see that positive effect of having a really good, effective, proactive detection program of work that has a really positive effect on leniency. So it makes it riskier for cartelists not to come forward for leniency. Last week, we launched a public consultation on our updated leniency guidance, and I would encourage everyone to have a look at it. We are aiming to make the guidance easier for firms to use by bringing it up to date with most recent developments in our policy and the way we handle leniency applications in practice. We are trying to streamline our procedures, and we also want to make sure that we have the right balance of incentives for companies and for individuals to be the first to apply for leniency. And we're really looking forward to receiving responses from stakeholders and moving forward with the guidance. So, yeah, it's quite a lot going on.
Wonderful, Lucilia. It's wonderful to hear from both of you that cartel enforcement is still alive. So, Andreas, you can rest quietly at the night. We're still doing our jobs. So, let's turn to Mr. Nuno Cunha Rodrigues, Presidente da Autoridade de Concorrência de Portugal.
Thank you, Diogo. I'd like to start by thanking Sarah Cardell and the CMA team for organizing this wonderful event. Even the weather is wonderful, which is amazing for Edinburgh standards. I think this is the city where sun is always present here. So, regarding cartels, I would like to highlight that the fight against cartels remains for the Portuguese priority. Competition authority has a priority. So, in a time when changing and enforcement is being challenged by technological evolution, the detection of collusive practices is no exception. So the truth is that we cannot expect cartels, which are the most harmful infringement to competition law, to be unchanged and locked in old-fashioned formats. This technology-led transformation paved the way to a major paradigm shift. So as a result, advanced forensic tools and specialized expertises are needed nowadays more than ever. So at the Portuguese authority, we are committed also to IT, and we've been strengthening our team with data scientists and IT specialists, and have been providing some IT training across various areas. So we have been able to recruit an expert from the criminal police, and we've been carrying out some down raids with the help of the criminal police also, sharing knowledge and carrying on those down raids. Moreover, the Portuguese authority has created a multidisciplinary digital task force that has been developing new tools to collect information, detect potential anti-competitive practices, and support investigation carried out by the ADC. For so, we have launched 3 major tools. The first one, we call it Screen IT, and it's a screening tool to identify collusive behavior between companies in public procurement, and I'll get back to this a little bit later. The second one is Scrap IT, which is a web scraping tool to collect online data, monitoring markets, namely online prices, and spotting indicia of potential price fixing. We are also seeking to improve the accuracy of the tools by training AI models based on the data obtained. And last but not least, we have a third tool, AI tool, which seeks to detect gun jumping by identifying documents similarity. We name it Detect IT. So we've got the Scrap IT, the Screen IT, and the Detect IT. Going back to the Screen IT tool, the truth is that we know that competition authorities have long used behavioral screens to detect potential collusion in public procurement data. So we have been also pursuing this avenue by securing access to e-procurement databases, which is now foreseen in the Portuguese Public Contracts Code as a result of our advocacy efforts. And we seek to identify patterns which are consistent with collusion. This has produced important results already and has allowed the Portuguese authority to secure the necessary warrants to undertake down raids, building on data analysis of suspicious patterns alone. Thus, detecting suspicious patterns on data is not only useful in building strong evidence-based case, but it also allows us to act early and to take a proactive approach. The use of data screening is truly relevant, but so is making sure that its methods keep evolving. Indeed, the implementation of new digital screening methods powered by advanced data collection technologies holds great potential, particularly with the use of algorithms and machine learning. So at the ADC, our aim is to keep up with AI and machine learning advancements to help us further improve the detection potential of anti-competitive practices and reliability. So although the bread and butter cartels are not out of sight, collusion today is taking new forms, adapting to changing market structures and emerging technologies. So enforcement must evolve alongside this change. This is a path that requires patience, investment, and resilience. But the truth is that the game-changing improvements can be just around the corner. So this means that we might be closer than ever to transforming these sophisticated techniques in a crucial part of our detection toolbox. And I'll stop here, Diogo.
Thank you, Nuno. Let's take a trip to South America with Mr. Jorge Grunberg, Fiscal Nacional de la Fiscalía del Chile.
Thank you, Diogo. Good morning to everyone. I would like to start by saying thanks to the CMA and the Cartel Working Group for inviting us to participate in this plenary and for the opportunity to share our perspective. With regard to proactive detection, first I would like to highlight that we have a strong track record in detecting cartels and initiating ex officio investigations. Almost 60% of the cases we have brought before courts in the last 10 years stemmed from ex officio investigations. Even though we have an effective leniency program like some other small economies, we don't depend on leniency. Only half of the cartel cases we had during the last 10 years had a leniency applicant. Our success rates before courts are the same with or without leniency. We have never lost a cartel case since Congress granted us in year 2009 information gathering powers and created the leniency program. Paramount to our proactive detection strategy is the intelligence unit created in year 2020. It is a multidisciplinary team composed of a lead attorney, a data scientist, economist, and a software developer. In the following months, we expect to further strengthen the team by incorporating 2 additional professionals specializing in economics and data science. The unit has been as useful for detection as it has been to support investigations. Like some of our sister agencies abroad, but probably in an earlier stage, we have been using technology to detect cartels, including artificial intelligence, machine learning, big data, and web scraping. To support investigations, we have implemented further improvements that make the execution of information gathering powers, dawn rates, phone logs, and wiretaps more effective. Specifically, in the context of phone logs, we have developed simple coding scripts to help us visualize the data. Phone logs contain valuable information that can be used, for example, to identify targets of interest and to group already known important targets in the same place. They can also be used to identify target routines and frequent routes, which are very valuable to prepare for dawn raids. This tool has already been successfully used in ongoing cartel investigations, and we have shared it with some peer agencies. Finally, I would like to say a few words regarding our recent accusation we submitted in October of last year in the casino industry, which can be considered a landmark case in the history of our agency for the following reasons. This is a bid rigging case in which the 3 most relevant casino operators sought to maintain their licenses for another 15 years until the years 2038 or 2039. Our investigation was initiated based on a claim submitted by the Superintendency of Casinos, the entity in charge of assigning the licenses. This is a demonstration that the collaboration between a regulator and a competition agency can be fruitful in the fight against cartels. During the investigation, we successfully carried out dawn raids in the private residences of 4 executives, based on our experience gained throughout the pandemic that was built importantly on the insights shared by our partners here in the ICN. Additionally, we count with evidence handed to us by a leniency applicant. In our accusation, we requested the Competition Tribunal to impose the highest fines in the history of the Chilean competition enforcement system for a total amount of more than $150 million, including not only the companies, but also 4 individuals that were top executives of the firms involved for a total amount of more than $2.5 million. Another interesting point to be mentioned here is that for the first time ever, we requested the Competition Tribunal to impose the measure contemplated in Section 26A of the Competition Act, consisting in the termination of the anti-competitive acts, in this case, the termination of the 15-year licenses to operate casinos. In our view, this delivers a clear deterrent signal for all the infrastructure operators in Chile, such as in telecommunications, sanitary services, highways, and airports. Congress mandated that such infrastructure be assigned through a competitive process, and the FNE will ensure that this is the case. Thank you.
Thank you, Jorge. Well, that concludes the initial remarks from our panelists, and then I will try to explore and expand on some topics that you mentioned with a round of follow-up questions. I will start with Ms. Derrick. New Zealand's authority has invested heavily in cultivating human intelligence networks and public reporting to target media campaigns in high-risk sectors like construction, for example. Could you share insights into how you build successful human intelligence networks and how you design the media campaigns and how you measure their effectiveness in generating actionable leads, especially when relying on whistleblowing or sector-specific outreach?
Thank you. Yes. I'll take each of those in turn in terms of building human intelligence networks first, and then I'll come on to the media campaigns. In terms of building human intelligence networks, how we go about it is at the start of each year, we sit down and identify those particular sectors or industries that we think are most susceptible to potential cartel conduct. We then allocate one of our investigators to each of those areas to set about building relationships or links within that industry or sector to the extent we don't already have them. 3 months or so in, we then sit down and assess the links that we've got, the extent to which we think they show potential and are worth developing further. As I've said earlier, it takes time to build these links. So one of the keys is not just building the initial relationships, but actually keeping those relationships warm, keeping on developing them. So we go back to them sort of every 3 months or so, just ask how business is going, ask how the sector's going. Very low key, but just keep those relationships alive. And as I say, we've been seeing that 2 or 3 years on, those bear fruit. There are obviously a lot of rules around how you interact with potential sources. In our case, we need to be careful. We can't ask them to do anything illegal. We can get them to wear a wire and record conversations they have, but we can't ask them to do anything they weren't intending to do any way. In talking to many agencies, they ask, what skills do you need to undertake this sort of activity? How do you go about it? And I guess our experience has been that when we look at the range of experience of our investigators, who can range from journalists, lawyers, business insolvency specialists, there's a range of skill sets there, all of which enable people to have skills of building relationships with people. And to the extent we're already doing outreach to businesses, it provides a platform in which we can build those relationships over time. But the key, as I said earlier, is continuing to follow up with those sources. So that deals with building the human relationships and how we're going about that. In terms of the media campaigns that I mentioned, as I said, we've been running these media campaigns for 3 years. We've run them twice each year. What we have done is a set of videos. One was focused on cartel conduct in the construction sector, and the other was cartel conduct between competing real estate agents. Those were our initial videos. The 3 lessons I think we've give you out of those experiences are, first, that we've got to keep the videos short, less than a minute, and that they have to be relatable and understandable by the audience. Secondly, they have to have a clear call to action. In the case of our videos, the final part of the video said, "Cartel conduct is a crime, report it." Very clear, very simple, but effective. And thirdly, I'd encourage you, if you're looking at a campaign like this, to make sure that the videos are reusable. It takes time and money to produce a video, so if you keep it general enough that it can be reused, as we've reused ours, that has been another secret, I think. In terms of the impact of the videos, we had 2 million views of the videos over the period of the videos. Of those 2 million views, that triggered 440,000 unique views to our reporting page and leniency page. We went back before we actually started the video campaigns. We set up random survey groups to actually assess people's knowledge of cartel conduct and whether it was a crime. And if you compare the results pre the campaign, it was a 60% awareness. After the campaigns, it was a 90% awareness of what cartel conduct was and it being a crime. And then, perhaps more importantly from our perspective, is what's the effectiveness of it in terms of triggering reporting through to our agency. We keep records of the complaints and reports to our organisation. During the period of the campaigns, there was a 240% increase in complaints regarding cartel conduct, and there was a 160% increase in action on our whistleblowing line. So we're certainly getting reactions. I can't tell you the identity of the actual cases, but certainly several of our current cases and some other recent prosecutions have all resulted from the media campaigns, with people that we've either interviewed or the leniency applicants signalling that they'd actually seen those videos and that had been influential in them deciding to come forward to us. So, thank you.
Thank you, Derek. It's amazing to see that in times of artificial intelligence and digital everything, we still have old traditional methods that works very well to raise awareness and to create compliance in the society. So I will turn to Lucilia. The UK has recently introduced debarment rules for companies found to violate competition rules, alongside other deterrence mechanisms such as director disqualification. How does these sanctions sit alongside more traditional cartel enforcement, and how do you ensure deterrence without chilling legitimate commercial behavior from these guys?
Thanks, Diogo, for asking this question, because it's something we've been giving quite a lot of thought to the CMA. So when it comes to egregious cartel behavior, which causes serious harm to consumers, to other businesses, and ultimately to the economy, I think it's absolutely right that this type of conduct is strongly deterred. And when we talk about deterrence, I think it's important to bear in mind that we mean not only bringing cases against those that infringe competition law and stopping that conduct, but also stopping others who might be tempted to engage in anti-competitive behavior. So it's not all about punishment, but it's about general compliance. And I think what this means is that as enforcers, it's really important that we take real care to ensure that our enforcement action that we take in individual cases is really well communicated and is amplified, so as to have the effect of also stopping future behavior that is harmful. So creating a kind of a virtuous circle of enforcement and deterrence work which reinforce one another. So how does that deterrent effect come about? So traditionally we think about financial penalties on companies, but that's not the only way. And this year we saw an important new law come into force in the UK, which has serious consequences for cartelists. So in short, if a business is found guilty of cartel activity, it will be prevented from bidding for public contracts for up to 5 years, or maybe prevented. And this doesn't apply, however, to successful immunity recipients. Includes when the immunity arises from a leniency application in other jurisdictions. So we want to protect incentives to apply for leniency in the UK, but elsewhere as well. And we think this is a really welcome legal development in the UK. So it goes to increase incentives to comply with the law while maintaining incentives to apply for leniency and to protect the public purse as well, bearing in mind the real focus we have at the moment on public sector procurement. You also mentioned our director disqualification powers. So in the UK, we hold those in position of power are personally liable for the businesses that they run. And to date, the CMA has secured the disqualification of 29 directors. So people who have been involved in cartel activity or the anti-competitive conduct. So they are now prevented from holding company directorships or from being involved in the management of a company for a period of time. This is a very powerful deterrence tool, and it's one that we really think that makes individuals sit up and listen. So both debarment and director disqualification now will be key levers, and they really complement and sit alongside the more traditional tools, and in particular corporate fines. But of course, fines still very important. And in the past decade, the CMA has imposed fines of over £750 million. And just to mention two recent examples, so earlier this year we issued infringement decisions in our UK government bonds investigation. 4 of the banks involved agreed to settle the case, and they paid fines of over £100 million between them. And that case was followed then by issuing penalties of £77 million in our car recycling case, in which we worked closely with the European Commission. So these are some really impactful fines, and we feel that these tools, they complement each other really well. Now, as much as deterrence is important, and as much as we recognize that deterrence only really happens when there is a real credible risk of getting caught and of serious consequences if you do get caught, we are also acutely aware of the importance of explaining how competition law applies to businesses so that it doesn't get on the way of legitimate business behavior. And one way we do this is by putting a lot of effort in making all of our external communications as clear, as consistent, and accessible to businesses and to general public as possible. So just to mention a few examples, every time we issue an infringement decision, we invariably accompany this decision with a press release drawing out key points. But then we also frequently publish easier to access, even easier to access blogs, explaining in layperson's terms what that case means. We publish articles in trade press. We run targeted anti-cartel campaigns with scenarios, again, that are accessible and relevant to business in real life. We recently published a blog about algorithmic collusion, which can sound as a really complex and dry topic, and it is indeed really, really complex, but we try to really translate it into accessible language, explaining the risks involved, but also helping those businesses who do use pricing algorithms, helping them stay on the right side of law. I mentioned earlier that we are consulting on our revised leniency guidance. So in addition to the leniency guidance, which is really detailed, we are also including some quick guides to businesses and to individuals to ensure that any potential applicants can, at a really quick look, understand what we know is a fairly complex regime. Another piece of work that we did is on green agreements. So we publish detailed guidance helping business understand how they can collaborate around green goals without breaking the law. So we published the guidance, and we also opened open door policy in relation to green agreements, which means that we can give companies tailored informal advice on how they can work together to boost the green economy. Our first year of operating this policy has demonstrated that there is a real appetite for this type of assurance and guidance. We have had approaches so far of about a dozen projects, all really interesting projects, and in 3 of them we've already published informal advice. Another piece of work that we did that goes towards explaining competition law is our work on competitor collaborations in pharmaceuticals. And here we worked in close collaboration with public health bodies to clarify where and how drug firms can work together on combination therapies for the treatment of serious conditions. And finally, in our plan, we have committed to provide further guidance to businesses on how they can collaborate to drive greater productivity and innovation, particularly in sectors of the UK industrial strategy. So yeah, I hope this gives some flavor of our position and how we're trying to balance those competing priorities.
Thank you, Lucilia. Just a quick follow-up question, if I may. Concerning debarment and disqualification, how are the judicial reviews about that? Do you have issues with that?
So debarment, the regime has just came into force, so we don't have the practical experience of debarment yet. On disqualifications, yes, we have had some cases gone to court, but we have managed to keep individuals disqualified.
Wonderful. Now, let me turn to Nuno. Evolving market structures have brought new challenges, including algorithmic collusion, buyer cartels, and competitive implications of sustainability agreement. How is the Autoridade de Concorrência adapting its enforcing toolkit to respond to these new forms of coordination? And what principles guide your agency in balancing legal certainty and proportionality, especially in cases involving green cooperation?
Thank you, Diogo. This is an interesting question. As an enforcer, when you perceive an enforcement gap, you should try to find a way to close it. At the ADC, we divide the approach to prompt awareness, leniency, and complaints. Indeed, our enforcement action develops hand in hand with the issuance of guidance and advocacy initiatives. I do believe that this integrated approach through the use of our toolbox help us to focus our battles on what actually matters for citizens, aligning competition goals with societal challenges while better understanding real people's concerns and frustrations. So I will start with labor markets, where we see a buyer cartel at the end. Competition law clearly establishes that fixing prices at which firms buy or sell may amount to an anti-competitive practices. It also states that sharing input resources can infringe competition law. And so, considering labor markets as any other input market means that we should close to enforcement gap and look at those markets. Other than several sanctioning decisions that we have taken at the authority and ongoing investigations in order to sanction labor markets and no-poach agreements and wage fixings, we have also issued a report and a best practice guides on anti-competitive agreements in the labor market, pursuing our advocacy strategy also. We have been quite vocal regarding these harmful practices, and for so we have been conducting advocacy sessions across the country to raise awareness about these type of infringements and the risk they represent, reaching out to different stakeholders, including workers' unions. I do think it's important for the authorities to leave the headquarters and talk to people, talk to citizens. And for so we've been particularly ambitious in our current advocacy efforts. In terms of the areas covered, so we've been talking about labor market, also about sustainability and fighting the classical bid reading cases. In terms of geographic coverage, so we've been doing that throughout the country and the spectrum of stakeholders involved. And we have also launched in this year, in 2025, a cycle of outreach and cross-border dialogue in key economic sectors, from health to education and housing, that we call Competition Plus Initiative. These allow us to bring topics that are new to our advocacy efforts, such as labor markets and sustainability, and at the same time to continue our ongoing efforts to reach out to public contracting agencies, while at the same time within the recipients of our message, including labor-related public entities, workers' representatives, environmentally related public entities, and entities committed to sustainability objectives, among others. This is why we believe that this initiative called Competition Plus captures well far-reaching nature we envision to our advocacy stance. These advocacy initiatives that I have just mentioned are crucial in powering our traditional detection tools. But the fact is that technology is a double-edged sword. It can improve efficiency in the markets and ensure effective competition enforcement, but it can also enable anti-competitive behavior in new shapes and forms. This is when the digital markets come out. Pricing algorithms are a prime example. Firms can resort to pricing algorithms in a collusive agreement to assisting in overcoming the hurdles of monitoring and matching, namely through the repricer tool, which is often a feature of pricing tools offered to vendors online. Furthermore, research has opened our eyes to the possibility of algorithm collusion achieved through the interaction between self-learning algorithms. And while earlier on such concerns seemed far-fetched, more recent research has shown that they are increasingly acute. Actually, AI-powered pricing algorithms may been shown to be able to speed up algorithm collusion and increase the likelihood with which they autonomously learn to set prices in a way that mimics collusive outcomes. And so in 2019, the Portuguese authority issued a paper on digital ecosystems, big data and algorithms, where we highlight the risk of some pricing algorithms could reach collusive equilibrium on their own. We also sought to widen our knowledge regarding the use of algorithms. For so, we try to understand first the prevalence of algorithms, and second, who is supplying algorithms to whom. And so we carried out surveys on the use of algorithms in Portugal, both economy-wide and in particular sectors. We also sought to reach out to price algorithms developers worldwide through requests of information that were sent to over 200 of such firms in order to learn which sectors and firms in Portugal they were supplying to. And this is certainly an area where we need to keep gathering information and we keep working on at the Portuguese authority. Now let me move to sustainability agreements. Because at the same time, sustainability agreements put competition authorities to the test. We must tell the difference between genuine public interest collaborations and anti-competitive behavior in disguise. This is another field in which advocacy plays a vital role, approaching the so-called competition greenwashing by providing clear and consistent guidance on what kind of collaboration is permitted under competition law, which might create legal certainty and avoids collusive behavior. That's the role that we've been doing through the advocacy that we've been promoting. And we've been doing that through the issuance of a best practice guide on sustainability agreements that followed the, I would say, famous European Commission's guidelines on sustainability agreements. On the one hand, these Portuguese guidelines suggest a positive approach to sustainability agreements and streamline the assessment of common sustainability agreements with minimal adverse impacts. These Portuguese guidelines follow the EU guidelines on sustainability and include three major elements related to the positive assessment of the agreements. The first one, the concept of sustainability, which includes not only environmental initiatives, but also social objectives, including labor and human rights. The second, the benefits for consumers, which are decisive for the competitive analysis of the agreements, and that do not include benefits for society in general, but only for consumers in the relevant markets. And thirdly, following the EU guidelines that provide a soft safe harbor for sustainability standards subject to 6 cumulative conditions. And so, by doing so, both following the EU guidelines and the paper that we produced in Portugal, we aim to encourage companies to establish sustainability agreements that advance society's welfare by improving the assessment process for these agreements. The implementation of these guidelines requires not only a close cooperation among competition authorities and the European Commission regarding these agreements, but also that competition authorities continue to advocate for their use and raise awareness for these goals. This is what the Portuguese authority did, participating at the ICN25 workshop on sustainability organized by the Autorité de la Concurrence, or when issuing its best practices guide. We do think that by mentioning the rules in an instructive manner and giving illustrative examples, the Portuguese guide helps to provide a helpful list of the assessment that companies should carry out to check if their agreements comply with competition law. So to conclude, these are the new challenges that we seek to synergize through our active efforts, both in terms of advocacy and enforcement. Indeed, applying competition law and intervening in behaviors that distort competition creates, as a byproduct, good things for society, including increased workers' welfare and more sustainable outcomes, among other things. So this is what we have been doing at the ADC. Thank you, Diogo.
Thank you, Nuno. Last but not least, I will stay with one topic that it's always recurring in the speeches. So let's talk about algorithmic collusion. Jorge, in your introduction, you referred to the creation of the intelligence unit in 2020 as a milestone of Chile's cartel enforcements. And during the 21st competition day in 2024, which was focused on algorithmic pricing and collusion, you stated that the Fiscalia is prepared to detect and prosecute algorithmic collusion, and that Chile's institutional framework is sufficiently mature to face this challenge. Could you elaborate on these points and explaining how Chilean competition law applies to the algorithmic collusion and describing the specific role of the intelligence unit in these efforts?
Thank you, Diogo. Well, during our 21st competition day on last December, with the presence of the economist Joe Harrington as keynote speaker, we expressed to the competition community that we are convinced that Chile's institutional framework is sufficiently mature to address the challenge posed by algorithmic collusion. We started with a word of caution. The FNE does not have a bias against algorithms or their use in business, as they can generate efficiencies and other positive externalities. However, as we all know, algorithms can also generate anti-competitive risks that could facilitate or even conceal a collusion. Technology cannot be at the service of anti-competitive infringements. Competition agencies must use technology to fight hard against the misuse of technology by companies and its executives. Certainly, compliance programs should play a significant complementary role in deterring such misuse. With respect to the law, it is important to highlight that the Chilean Competition Act contains provisions with an open and versatile framework capable of encompassing a variety of anti-competitive infringements, including in this case not only agreements but also concerted practices. The concept of concerted practices should be particularly suitable for addressing some cases of algorithmic collusion. When investigating algorithmic collusion, our current investigation powers pose a few challenges. We believe that the FNE is prepared to address them. Let me give you a few examples. First, RFIs may require cooperation of undertakings to avoid litigation during the investigation. This is especially relevant in algorithmic collusion investigations, where the information that is needed requires in general access to proprietary codes and sophisticated technical explanations. Of course, in the law, we have tools to require access to proprietary codes or to obtain such explanations, but of course the ideal scenario is not to be in the need of using them. Second, in case of done rates, the obtention of access to cloud servers, large databases, and algorithms is also a relevant challenge that competition agencies must face in these types of cases. Furthermore, it is essential to recognize that the use of algorithms presents a direct challenge to the traditional analysis of information. Specifically, the issue lies in the fact that the conditions observable on a given day regarding the coherence and operation of the algorithmic code may differ substantially within a matter of days or even hours. Consequently, regardless of the method used to obtain the information, it is relevant that such data be accompanied by and subject to verification against a detailed and timely explanatory statement from the company under investigation. Algorithmic collusion is not the only concern of the intelligence unit nowadays. I would like to tell you about a particular tool that the unit has been working on, which also highlights the need to strengthen interinstitutional relationships for an effective fight against cartels. Through an institutional collaboration agreement with the agency responsible for the centralization of public procurement in Chile, Chile Compra, the intelligence unit has developed a tool capable of analyzing public tenders and is working on implementing certain markers to detect indicative behaviors of collusion, which will then be verified using the investigative powers of the FNE's anti-cartel division. Thank you.
Thank you, Jorge. It's always good to hear that we're still innovating in the cartel enforcement, even though we rely also on traditional methods. And I think this is the message of this session, how it's essential to cartel enforcement to combine traditional methods of investigation with the new ones in order to keep going and to catching up with the new methods of infringement. So let's make, we are about 8 minutes to go, so let's make a final wrap up. So I will give the floor for you to make final remarks or to jump in what with each other speeches and so on. So I will start with Derek. Let's keep the line. I will start with Derek, then Lucilia, Nuno, and Jorge.
Certainly a number of common themes coming through here in terms of the use of sustainability guidance. I think it's something that we're seeing across a lot of jurisdictions, a lot of thought about algorithmic collusion. In New Zealand, it's an interesting issue at the moment, given the state of our legislation. I think the view is that although our legislation is pretty general, that there's opportunity there to take an action in relation to that if we needed to, and particularly in terms of action against individuals, because we've got powers to take action against any individual who aids, abets, is engaged or knowingly concerned in any contravention. So once you can show a contravention in terms of an agreement by algorithmic collusion, then you can take action against all the individuals directly or indirectly involved. So that's useful. So I think these are all interesting issues that we're all grappling with across the globe.
So I would just like to make a quick plug to the final draft of the Dawn Raids manual that is has been done by the Cartels Working Group. So I say final draft because I think it's formally going to be hopefully approved by the ICN members at this annual conference. So this work was it was a project team led by the CMA and a number of other agencies from across the world, so Brazil, Canada, Spain, Mexico, and Korea. And we worked together to update the Dawn Raids manual from the ICN, which dated 2009. And if you think back in 2009, I'm pretty sure that the way of getting through the door of a company is the same as today, but everything else has changed, right? So in particular, the way that, these days you find evidence generally in digital format, the fact that people work from home, carry phones, mobile phones with lots of evidence in it, and so on. I think the project team did a really awesome work of bringing the manual to present day. They also made a real effort to make sure that the manual is relevant to agencies across the world. So that goes all the way from very experienced, mature, well-resourced agencies, all the way to agencies who are newer to cartel enforcement, have less experience or fewer resources. Have a look next time you're planning a raid, because I think it's really a great work product.
Yeah, I'd just like to highlight the importance of international cooperation when it comes to fighting cartels. Cartels are no longer national, they are cross-border cartels, international cartels, and for that we need to share our experience, our knowledge, to exchange information between authorities, to create an atmosphere of trust. And that's why we are here at the ICN. The ICN is fundamental to create this atmosphere of trust that allow us, when we get back home, to share information and to pursue our investigations that are no longer in national investigations, but international investigations between our teams. And for that, I do think that we need to foster international cooperation, not only through ICN, we'll be doing that within the EU, with the ECN, which is a very important network within the European Union that was created by the famous Reg 1, and that it keep working, and that allow us within the European Union to share information between authorities. So we have to promote that also internationally by the ICN, the OECD, and we'll be doing that in Portugal. Portugal is a very open country, and also when it comes to competition, to the application of competition law, we've been sharing information and learning with other authorities and trying to, through that, fight the cartels and investigate cartels. So it's very important to have these forums and to create, once again, this atmosphere of trust, of knowledge between us. Thank you, Diogo.
Thank you. Jorge, please.
Yes, I would like to back Nuno's thoughts on international cooperation. As we have mentioned in other opportunities, international cooperation has been key for the FNE strategy in fighting cartels. This collaboration has been essential not only for training and sharing experience, but also for supporting our investigations. The fight against algorithmic collusion is no exception. We have been engaged in constructive dialogue with sister agencies to address the significant challenges posed by this type of conduct. The FNE is fully committed to collaborating with our ICN peers when needed.
Thank you very much. I think we are about time. I will just keep with the message of international cooperation and the importance of ICN. I think it was very important and is still important to Brazil and for all countries that are presented here. I hope that this panel presented you a whole menu of how we do enforcement in cartels and how the combination of the tools, of modern tools and traditional tools can improve our activity. And now I would ask you to join me in a round of applause for our wonderful panelists. Thank you.
Good morning, everybody. For our next session this morning, I'm absolutely delighted to welcome Executive Vice President of the European Commission, Teresa Ribera. Teresa, you need absolutely no introduction, and I know you've got an incredibly busy schedule, so we are so pleased to welcome you and very, very grateful for you taking the time out to join us today. You come with an incredibly interesting mandate that covers environmental issues, competition policy. Really fascinated to hear what you have to say, and I know we're going to have a really great discussion. So shall we dive straight in? And perhaps you can just kick off with just a brief sort of introduction in terms of your experience in the early months of your mandate as EVP.
No, thank you so much, and just to start, thanks a lot for organizing this meeting and having a chance to exchange views with you all, because I think that it is very important having the opportunity to exchange views, to work together, to build alliance is quite an important issue in whatever field, but very much in particular in this field, now that we know that markets are global and that ensuring a well-functioning, level playing field around the globe is so important. I could say that for me it's been a great dive into this world of competition. It's not because it is not clearly one of those very relevant instruments to ensure, as I said, the level playing field, but also to learn and to have a chance to get deeper into how market forces do work right now in such a complicated but passionate world trends. And I think that to me these months have also proven to be quite important in order to identify what are the main challenges to be responded, how we can work to ensure that we can count on a healthy enforcement of competition laws, how we can get into an exercise to update the guidelines that we apply and that bound ourselves when tackling the different competition tools, how we can introduce these competition tools in such a way that are consistent with the way we understand we can help back into the community, the society, because at the end, the whole competition policy was born very much to help the society to be much more healthier, well-functioning, and we've done lots of things. It's been the first 5 months where we came up with this notion of the clean industrial deal, and to what extent this clean industrial deal, in order to improve competitiveness and modernization of the industry in Europe, may relate back to the way we understand how we can assess state aid to cover the eventual market failures in this field, to what extent mergers or antitrust or dominant positions in the market may be read in a different manner, to what extent these new players in the digital world could comply with the digital regulation that provides upfront guidance on what can be done and what cannot be done, so to ensure that innovation has a chance in the digital market. So it's been passionate. I'm happy to be here.
It's fascinating, and actually that point about what is the purpose of for all of us ensuring markets are competitive. We had a discussion in our heads of agency session yesterday about competition to serve society and how do we achieve that. I think it's such an important theme at the moment to make sure it's really relevant for society, the work that we do. But your mandate, as you've just said, it covers the clean, just, competitive transition. It covers competition policy. And perhaps you could just tell us a little bit more about how you see the interactions between those different areas and how you're thinking about that in a sort of joined up way as part of your overall mandate.
No, thank you for the question, and I come back to what I have just said. In fact, as you said, competition was born to provide this comfort to the society and to the economic players and so on, and to be bound by the rule of law that could ensure that there were someone paying attention on how well we perform as a society. But in order to understand how it evolves, having a deep understanding on what are the green forces in the market are very important. I think that for the time being, modernizing the industry, understanding how shareholders may take decisions on where they can bet on the future is very much related on how efficient we are in the use of resources, how promising these clean technologies may be, how it can impact back to consumers with claims that are not real and that can confuse investors or consumers. So there is an approach that was already present in the way antitrust authorities were playing their roles that becomes increasingly important, so to update the way we play with the competition tools in our society. And I think that this is part of what we intend to do. We are trying to identify how the different traditional tools, state aid, mergers, regulations, antitrust regulation, do understand and take into consideration and factor in this type of relevant issues in any given market, in any given society, and at the very same time, to what extent the new approaches in a world that has changed, where, of course, we are an open economy, there may be investors and industrials pretty interested to enter into a given market, such as the European market, but we pay attention to our players, so we need to pay attention to what extent the level playing field rests assured, and this was why we adopted the foreign subsidies regulation to be sure that there was not an uncomfortable and unfair situation for those complying with the regulation in the European markets, or to what extent digital may play a role, but innovation should not be killed, and consumers deserve protection. So how well it could perform according to the existing rules.
It's fascinating, isn't it? Because it captures so many of the different themes that we tend to think about as competition authorities. You know, we think about digital and the development of emerging technologies. We think about that sort of consumer experience and making sure that they are getting the best out of markets as markets are emerging and developing, that level playing field for competitors. All of those things come together really when we're thinking about the green transition in quite a unique way, I guess, and particularly when you're thinking about that on a European basis. It's a fascinating area. And if you sort of talk us through a little bit more in terms of your particular priorities as EVP. We had a really interesting discussion in one of the panel sessions we had yesterday about the interaction between competition policy and industrial strategy, the role of competition in driving economic growth, innovation. We've already talked about that in the context of green transition. But how do you see your priorities more broadly, but also specifically when thinking about those themes as obviously highly topical at the moment in terms of the economic climate for all of us trying to promote economic growth, encourage innovation? What are your priorities in that space?
The official boring answer could be my mission letter states what I need to do and to what extent I have to pay attention together with the team in the DG competition to ensure that a proper evolution of the competition policy takes place. So to accommodate to today's realities of the 21st century. And I think that this is quite important. We do not start from the scratch. I think that much has been done along the years in a very cooperative manner with different national competition authorities, or not only in the European context, but beyond. I think that this can be also built along the lines of the very recent experience. We have gone through, traumatic experiences in terms of how we needed to react to the COVID recovery, how we needed to react to the crisis being provoked by the invasion of Ukraine by Russia and the impact on the energy and then in the economy. And I think that the combination on whether we can bet on the modernization of the industry, how it can impact in a positive way on citizens, consumers, innovation, capacities, retaining talent, and so on, has already been reflected in some of the very first products, outcomes coming from this commission, and some of them are being announced. I think that what I would like to see at the end of the mandate is that we have been able to ensure that a proper evolution on the understanding of the competition tools has taken place. Today, we are launching a process to assess to what extent we can update the guidelines dealing with mergers, to what extent there is a possibility to introduce in the reference that we take into consideration when assessing mergers, horizontal or non-horizontal, a much more broader understanding. What about the security in the value chain? What about innovation? What about the dynamic approach? So to understand that time may play differently, how we can provide a better understanding on sustainability patterns, or how we can take into consideration that there may be an important goal for the business community to bet on sustainability and decarbonization as a means to ensure that things can happen, and that may require a different dimension, a different size, an enlargement of the vision of any given company in any given sector. So I think that this is one of those examples, together with this idea of, yes, of course, we have learned a lot, thanks to the fact that unluckily we had to provide support to our companies or to our citizens in the previous crisis. This may help us to understand to what extent, when we are betting on a much more cleaner industry, we may be providing some guidelines to support decisions on state aid that do not create an unlevel playing field, or make something which is very important in the European Union, which is cohesion, territorial cohesion, so not to allow that those that have a bigger fiscal space get all the credit to bet on industry, and those that do not have so much fiscal space do not have the capacity to retain talent and to retain industry. We have got the first experiences dealing with digital markets, and I would say that it has been quite positive in many different cases, but it is also providing a good basis to keep on learning on how we can ensure a culture of compliance and ensure that these are markets open for those new innovators that want to challenge the incumbents and to count on a capacity to enter in the market. So I think that the whole set of things that show to what extent we are able to update the way we develop practice in competition, together with a large community all over the world that to a certain extent face very similar type of problems, is challenging, is good, but it goes very much in line with what we understand are our values, our principles, and even we can recognize the very much relevant principles of the origin of this antitrust reality.
And I think that resonates so much with so many of the conversations we've been having at the conference over the last 24 hours, you know, that sense that as practitioners, as leaders of our agencies, we need to make sure that the toolkit that we have remains relevant, that it remains capable of addressing the issues that we're seeing here and now, that we can see in those emerging sectors, to ensure that we can keep markets working really well. So it's very, very interesting to hear. And you mentioned the benefit in that context of having an international network where we can have these kind of discussions. But obviously for the European Commission, you're already operating in that international space. You've got the ongoing day-to-day coordination across all of the member states. How do you think about the broader role of international cooperation, whether that's through bilateral activity with other agencies or multilateral fora like the ICN, the OECD? What do you see the role of international cooperation in enabling us to take forward these sorts of priorities together?
I think this is such an important setting. I mean, I'm a true believer of diplomacy of friendship, and I think that changing views on how we can improve the quality of our work is a great thing. Take into consideration what I have already mentioned a couple of times, digital markets. I think it is key. We need international cooperation on digital markets performing well. that does not prevent the fact that there may be some authorities that think that the best way is to intervene in a post-case situation whenever an infringement in the antitrust law has taken place, and there are some others, like in our case, that think that it is easier, cheaper, and much more safer to have an upfront guidance on what we can do or what we cannot do for those that have a big position, a relevant position in the digital markets, and it has proven to be quite effective. I could say that many improvements for the day-to-day life for the operators in the European market or the final consumers at the households have experienced the benefits of this upfront regulation on what to do and what not to do in the Digital Markets Act. But that does not prevent that we appreciate international cooperation, because we know that even if we represent more or less a third of the business for these operators worldwide, they operate in the entire world. So you may be facing similar situations, and it is good to attention on how you face these issues. And it happens in many other circumstances or traditional ways to deal with competition instruments. It may happen with international mergers. It may happen with positions of dominance in a given market. It may happen to understand how we can avoid killer acquisitions. So I think that it is not only important to work at the European level with the national authorities dealing with competition, something that we already do, and that it is quite healthy and thrilling and fantastic. It is also very, very important to have the possibility to work together at the international arena. And according to my own experience in other fields, but also in this field, when we understand each other, even to identify where we agree or where we do not agree, or where there may be difficult challenges that we address in a different way, is so important to have a clear understanding on why we do, how we can expect a given solution or a given statement, decision on whatever, and how we can learn from each other where there may be room for improvement in our own way to proceed. So I think that that international cooperation in this field is fantastic, and I think that this type of settings are quite useful to exchange views and to improve our capacities for the day-to-day practice back home, knowing each other and knowing that we can count on each other whenever we identify a tricky issue that deserves sound solutions and that may be tackled by some other colleagues somewhere else, and it is better to learn and to understand how, when, and why.
Yeah, and it's very interesting. I've been reflecting as we were preparing to host the annual conference this year on the history of the ICN and the real importance of coming together, as you say, to identify those common issues, those common themes. It doesn't mean that we all go about tackling them in exactly the same way, and it's good to have a healthy debate and discussion about that. But I think that sense of understanding where the issues are and that opportunity to build relationships, as we've been able to do at the conference and through the ICN, is a really important part of how we globally start to tackle some of these issues. I mean, maybe just as a sort of final word for delegates, are there any sort of particular priorities or opportunities you see for international bodies such as the ICN? Any words of advice or encouragement that you would give to our delegates as we continue through to the end of the conference and beyond?
Well, a long time ago I studied law. So I appreciate the rule of law, and I appreciate the principle of cooperation and mutual understanding and mutual respect. And I think that in this field is particularly important. We are in a period where we have evolved from each one on her own national reality towards a period where everything seemed to be quite fluent and quite flexible. And now we realize that this meant that we enter into a new phase where we identify new challenges, difficulties, and I think that the right answer to these challenges is to understand each other much better. So to pay attention to this mutual respect and to try to remember the face of those leading this national authority, having a very similar problem. Probably it's good to get the phone and to call and to say, hey, why you are doing that and what it is going on and how we can be increasingly consistent. Not because we are going to do exactly the same, not because the national circumstance of each of us may be the same. That's certainly not the case. We may have different regulation solutions, different social settings or expectations, but it is always good to exchange, and it is always appreciated when you get a message from a colleague to say, hey, I have a problem, or I don't like what you are doing, instead of sending messages out to the crowd, screaming and claiming I don't know what. I think it is better to have a nice conversation to understand what it is going on and to have a capacity to solve or to respond any misunderstandings, but to trust each other.
And it's certainly, I think, for the ICN, that spirit of that shared endeavour, which we I think all have a good sense of, and we've had some great conversations at the heads of agency and other sessions. I think really bringing together that community, and I think that is really what the ICN embodies. So thank you again so much for your time this morning. We're really, really grateful to you, EVP, for joining us, and just a final round of applause, appreciation to EVP Ribera.
So my great pleasure. We wait for your calls, and we may call you. Bye, thank you.
Good morning. I know this is a hard act to follow, but if you would take your seats, we will start with our next plenary session. Thank you. Good morning, everyone. This plenary session and this morning, we're going to talk about food. This is a topic that is dear to all of us, to everyone, no matter how big or small you are as a country, no matter how rich or poor. And we've seen this quite incredibly in the last few years with the food price inflation that we've seen all over the world, whether you're living in Europe or in Africa or in Asia or in the Americas. This food price inflation has been fueling the cost of living crisis that so many have been facing. But for millions of people who live in low and middle income countries, this question of food and agriculture goes to the heart of how they can get out of hunger and poverty. It goes to the heart of the development question. And so it's more than just about food to eat. It's about food as a source of income or employment. It's about food as a source of security and livelihood. And that's why I'm very pleased to be here. My name is Karen Smaller, by the way. I'm an NGA for the COMESA Competition Commission, so thank you to COMESA for inviting me to be here. And this plenary, which we call Global Market Power in Food and Agricultural Markets, is really here to showcase some of the work of the ICN's special project on food and agriculture that is importantly co-chaired by Kenya and South Africa. And so thank you for inviting me to moderate this session. The plenary is going to look at food and agricultural value chains, which has been the subject of this ICN special project. And during this special project, what we've seen is that often the conduct in agricultural and food value chains has had this cross-border dimension. We heard about it in the morning session on cartels, and it raises a lot of questions for merger control. Our plenary really has two main purposes. The first is to hear how the competition agencies here with me today are both identifying and enforcing against anti-competitive arrangements in agricultural and food markets. And our speakers are going to share lessons from their market inquiries, studies, and cases. We're going to look at input markets, we're going to look at processes, and we're going to look at retail today. The issue of traders, also critically important, is going to be dealt with in a separate breakout session tomorrow when we will look at the Bunge-Viterra merger and the Sustain IT joint venture. So if you want to hear more about traders, it's in the breakout session tomorrow. The second purpose of our plenary is to charter a way forward for the ICN special project on food and agriculture so that we can keep helping competition agencies address these issues and cooperate better together. I mean, that's been a real theme this morning, both in the cartels working group and in the keynote speech we had today. Very important theme also on food and agriculture. So, before I hand over to our speakers, I just want to take 1 minute to recap what has actually emerged from the special project to date. So many of you took part in the survey, which really highlighted how important this issue is across the ICN membership. And it was deepened through ongoing sharing of experiences, cases, and inquiries. One of the common concerns that emerged was this challenge in tackling international concentration and cross-border markets, and how important it is to cooperate together to tackle these issues. There's been identifying the huge benefit to share methodologies on collecting information, how you get your data sources, and how we can share better research and analysis. There's also, linked to our second purpose for this plenary, the idea of where to now and how do we charter a way forward. And there are some ideas that have emerged that I hope will also come out in this plenary about working together on templates or tools for methodologies for price monitoring, building methodologies through deep dives into particular cases, and the issues around fertilizers, feed, poultry, and seeds has emerged quite a lot. An overarching paper on this broader issue of international concentration and cross-border issues. And then finally, pretty straightforward, having a knowledge base where all this information can be stored. One more slide from me and then I'm handing over. We have created a QR code that you can take a photo of now, which basically puts together all of the studies that you're going to hear spoken about today. So if you want more information about these market studies, we have a page that we've put together with all of our countries' studies on them. On that paper, you also have access to the African Markets Observatory, which is being run by the University of Johannesburg Centre on Competition Regulation and Economic Development, and my organization, Shamba Centre's Agri-Food Monopoly Tracker, which tries and looks at cases that are taken in Africa around agri-food markets. So now we turn to our panel. We want to hear more from you. Let's start with Mr. David Kamei, who's the Director General of the Competition Authority of Kenya, and he's also the co-chair of the special project. Mr. Kamei, Kenya's recently published an animal feed inquiry. Can you share with us what did you find in this inquiry, what did you learn, and what are you planning to do next?
Thank you very much, Karine, for the opportunity. Let me start by thanking Sarah and our team at CMA for this wonderful and amazing conference. The organization is superb. We are happy about it. Now to go to the question that she has asked me is that we found the following in our study. Again, she has given the background that this is a special project of ICN, which we took it up, and these are the following findings for this project. Number one is that we found that the prices were actually increasing, and therefore the results reflected structural issues in the animal feed sector, which is a critical input in livestock production in Kenya and in the rest of the world. The inquiry also assessed the entire value chain for key inputs like maize, soy meal, sunflower cake, to feed manufacturing and distribution, and several critical findings emerged as follows. Number one, we found that there are actually supra-competitive pricing of inputs. The price of key protein inputs was found to be significantly higher than would be expected under competitive market conditions. This is due in part to reliance on imports, where large international suppliers charge Kenyan farms more than other markets and re-export excess supply to countries like India and China. This artificial scarcity raises costs and sidelines smaller feed producers. In addition to that, we found that we found some opaque input markets. The supply of inputs is dominated by brokers and intermediaries, operating without transparency. Therefore, prices are often arbitrary, negotiated by delivery, not actually set in supply-demand fundamentals. The other finding is that we found seasonality and cross-border challenges. The supply of key inputs like maize is highly seasonal and heavily reliant on imports from Uganda and Tanzania, but non-tariff barriers, export restrictions, and inconsistent enforcement at borders actually drive up costs and increase the risk of contaminated feedstock. The other finding was disjointed domestic regulation, where we find the local taxes by our counties lead to double taxation in some cases as goods move across the counties. For instance, transporters with branded vehicles pay extra even after paying levies at the point of origin. These local fees inflate the costs of feed. Those are the main aspects that we found in that study. Thank you very much.
Thank you. I would now like to move to Hungary, where you had very skyrocketing dairy prices in the post-COVID period, and you were really concerned about these and initiated this accelerated sector inquiry into the milk value chain. And if I understand correctly, you didn't just look at the processing level, but you looked at the entire value chain. So we have with us here today Mr. Csaborigo from the Hungarian Competition Authority. Can you tell us more about this experience? How did you find the information? What did you discover? And what are you planning to do about it?
Thank you, Karen. First of all, I would like to say thank you for Sarah and the ICN event team for organizing this wonderful event. Thank you for the opportunity to share the insights from the Hungarian competition authorities, GVH, work on the dairy sector, particularly regarding cross-border issues across the value chain. In our dairy sector analysis, we thoroughly examined the entire supply chain from farms to processing firms all the way to retail. We found that cross-border issues are present at every level. At the farming stage, global input markets have a significant impact. Fertilizer prices, for instance, are heavily influenced by natural gas price movements worldwide. Similarly, the drought has pushed up the prices of animal feed globally. As you know, in 2020, in Carpathian Basin, there was a very serious drought. Moreover, within the European Union, raw materials such as milk can be easily transported. While this mitigates local production shortages, it also means that prices tend to correlate strongly across the EU countries, making local markets highly sensitive to external shocks. When it comes to processing and retailing, cross-border effects remain substantial. Many input materials, packaging, machinery, and additives are imported from countries like China or other developing or developed economies, despite the fact that the main raw materials, raw milk, is predominantly domestic. The import prices of the final products significantly influence domestic price negotiations. When imports became more difficult, for instance, during the COVID-19 pandemic or due to logistic disruptions, local manufacturers gained room to raise their prices and profitability. It also highlights the fact that reducing trade restrictions can lead to favorable effects on the domestic market. Nevertheless, it is not a coincidence that the new vision for EU agriculture and food published in 2025 ends with the imperative of strengthening food sovereignty and strategic autonomy. At this turbulent time, we cannot interpret any public policy issue without its geopolitical context. Member states of the EU, within the active engagement of their competition authorities, can formulate key recommendations at national level in order to contribute to the objective of food sovereignty, as is shown by our analysis. Its key conclusion is that even when the main inputs are locally sourced, international factors heavily impact pricing. No country, not even those self-sufficient in food production, can shield itself entirely from global price movements. Nevertheless, local factors still play a role and can lead to some deviation from global prices. For example, the elimination of the raw milk price forecast published by the Hungarian Dairy Board have stabilized domestic prices, showing that national measures can have a meaningful effect. These findings underline the importance of international cooperation projects like those of the ICN, which provide valuable platforms for sharing experience and good practices across the borders. Let me also briefly touch on the tools the GVH uses to monitor these dynamics from a competition perspective. We rely on a combination of databases to track developments across the entire supply chain. The competition statistics database provides us with a broad economic overview, while our price monitoring database, Price Spotter system, known locally as the Árfigyelő in Hungarian language, offers real-time insights into price movements. To complement these resources, we also use external sources such as market data, prices, volumes from the Institute of Agriculture Economics. Together, these tools help us better understand market developments, identifying competition concerns, and intervene when necessary, supporting both consumers and market stability and increase product market competition. Thank you for your attention.
Thank you. So we've heard two interesting cases in two very different contexts, but dealing with input and processing sectors, and feed in dairy, and in Kenya's case, feed also for poultry. I want to now move to the supermarkets, all the other way at the end of the chain, and hear from Ms. Gina Cass-Gottlieb, who's the chair of the Australian Competition and Consumer Commission. You've just published a supermarkets inquiry a few months ago, alongside a number of other food and agricultural inquiries that were published in earlier years on dairy, beef and wine. But let's focus on the supermarkets one. What did you find out about the supermarket sector? But more importantly, what lessons did you learn as an agency for collecting information about this segment? And what can you do about it? So we've heard a lot of what we found, some about the tools we were using, but again, what action are we able to take with this information that we're gathering?
Thanks very much, Karen. I also want to thank the CMA and the co-chairs of this special project, South Africa and Kenya, for allowing me to be able to share the experience of the ACCC here. So I want to start by giving you a quick sense of the value chain in Australia. So we have a relatively fragmented farmer community in terms of supply of agricultural products. We then have more concentration at the processing level, and in the past the ACCC has opposed mergers of processors, particularly in the dairy sector, We then have at the supermarket sector quite a highly concentrated level at retailing. So we have two very large, having 67% market share, called Coles and Woolworths. We have had the successful entry of Aldi, very fortunately, which provides at the hard discount level some real discounting in price and competition on price in home brand and their limited set of fresh and dairy. And importantly to note for all the enforcers here and who share an enforcement stance and posture, in part the ability of Aldi to expand across Australia was a result of what the ACCC had found in an earlier supermarkets inquiry in 2008, when the ACCC found that there were restrictive covenants in leases put there by the two largest players, Coles and Woolworths, which prevented Aldi being able to enter as a second supermarket in many of the desirable shopping centres in urban Australia. So after that enforcement investigation and a commitment, which meant that those covenants, restrictive covenants, could not be enforced and not be entered into in the future, Aldi expanded from 150 stores to 650 stores, which was a very important intervention to increase competition at the supermarket sector, but it is still not sufficiently significant because of the limited product set. And then there are independent supermarkets who are smaller, small business, can't compete largely on price because they acquire at a lower scale, but compete by differentiating their service and their convenience, and they are also generally the bigger proportion of supermarkets in rural and remote areas. What we then found was that because of this significant dominant position of the two largest retailers, that there was a material imbalance of bargaining power with our more fragmented suppliers. This resulted in the suppliers were required to give an absolute fixed commitment to supply at volume and price, but the two largest supermarkets, and Aldi actually behaved quite differently, interestingly, the two largest supermarkets would unilaterally change the volume depending upon their assessment, even week to week, the volume that they were purchasing and also the price, whereas Aldi did give commitments to its forecasts to the farm sector. The impact of that, particularly on farmers like fresh produce for dairy and beef, they have an export constraint, and so they are less subject to and less reliant upon the two largest supermarkets. But for fresh produce suppliers, we have had farmers leave the sector altogether because they cease to be able to receive any return to have a sustainable farm business when they have to invest and meet their commitments, but then they do not receive the revenue. What we found is a consumer sector, so for consumers we have a combination of highly urbanised population. Most of our population, over 90%, will be in the urbanised fringe of Australia, but then there we have a diversity of higher income to lower income communities, and then we have regional and remote communities, some of which are extremely disadvantaged members of our community and of our population. We found at the consumer level that consumers were seriously affected by the increase in price. So price increased over the past 5 years, significant, that is food and grocery prices, significantly higher than the general CPI and then the wage price index. We used a consumer survey in order to get input from consumers, and the consumer survey told us at least 25% of the people responding feel stress entering a supermarket because they cannot afford what they need to buy, that they have shifted, and people will see Australia as a relatively wealthy, in world terms, country. But so we had 25% of our consumers telling us they were shifting to lower price goods, home brand goods, frozen vegetables and fruit rather than fresh, and that many parents in a family were skipping meals because actually they had reached a stage of challenge on their food security. So this is not something at those levels we were necessarily expecting, but it was something that came very loud and clear from consumers. The way we gathered the information was through submissions, through supplier roundtables, some of them conducted very confidentially because suppliers were fearful of retribution from the major retailers. We use the consumer survey and we use compulsory information and data collection powers. What do we want to do about this? So we've made recommendations in terms, so looking at the problem we found at the supplier imbalance of bargaining power. We have a food and grocery code so that the government has put in place to deal with supplier engagement, but it allows the supermarkets to negotiate out of it. And for many of the suppliers, in that circumstance, they agree that there would be a negotiation out. So we have recommended that there be mandatory minimum protections, including in relation to an inability to unilaterally change price or unilaterally change volume. We have also recommended that there is an obligation for there to be much more transparency and detail in the forecasting that is given by the supermarkets to suppliers, and in addition that there is much more transparency, which indeed the ALDI process had, in terms of the manner of weekly tendering to acquire and then pay for the products. At the consumer level, we recommended, in order to allow effective price comparison for consumers who need to really get value for their grocery spend, we recommended that each of the supermarkets needed to have online up-to-date dynamic prices, that the two largest supermarkets need to provide an API with dynamic pricing to allow comparison websites to put up meaningful comparisons, that also that they need to remove the confusion that consumers are having so that pricing is on a unit price basis, price per gram, price per volume, so consumers can compare between the different products. And if there is a reduction in packaging, many of you I'm sure will see this, particularly if you're also a consumer protection agency, what's called shrinkflation, that if there is a reduction in size in packaging, which often still is at the same previous price, so a price increase, that there's a requirement to actually put up a ticket on the shelf that shows that there has been a reduction in size.
Thank you. So pretty alarming stories all across in how consumers are really being hit by these big food price increases, but also great to hear all the tools that are being put in place. Ms. Cass-Gottlieb, you've mentioned a number now around price monitoring and transparency, the food and grocery code. Let's move to Saudi Arabia, where I believe you have just released last week your first fresh fruit and vegetable market inquiry. Dr. Fahad Al-Shatri is the head of Saudi Arabia's General Authority for Competition. You mentioned to me when we spoke that this fruit and veg market inquiry revealed a number of cross-border issues as well because of how dependent you are on imports for your fruit and vegetables. What are the main findings from your report, and how are you planning to respond?
Thank you, Karen, and I would like also to take this opportunity to thank our host, the CMA, and the organizer, the ICN, for the excellent organization and hosting. I hope our story is less alarming than the three stories here, but let me start with explaining the structure of the agriculture sector in Saudi Arabia. As you know, natural conditions in the Kingdom of Saudi Arabia is not favorable for a wide production of agricultural products. Therefore, there is more reliance, as you mentioned, on the import products. Given just some figures that indicate the high reliance on the imports, 90% of our wheat demand are imported, as well as 72% of fruits and vegetables also imported. The dates in Saudi Arabia is the exception, where Saudi Arabia is the second largest supplier of dates globally. Also, there were many policies by the government that led recently to self-sufficiency in the raw milk and eggs, as well as reducing the dependence on the imports in the fresh fruits that decreased from 85% to 65% in 2022. Two important results to keep in mind from these figures. First, food security is and competition issues are less focused on the response to natural events and more focused on the structural aspects in relation to reliance on import, as I mentioned, and local production. And the second point, which is government support is needed for food security, but it's important from GAC perspective to balance that with competition. Therefore, GAC advocates for three issues with regard to fruits and vegetable markets. First, ensuring competitive neutrality between public and private suppliers. And second, fairness of competition between small and large businesses that supply fruits and vegetables. And finally, the third, which is policy coherence, balancing the different objectives with regard to competition. Moving to the results or the findings of the fruits and vegetable study, it shows that there were a steady growth in terms of the demand in recent years as a result of the growing population, reaching 7.1 billion US dollar in 2024 compared to only 6.1 billion US dollar in 2020. The market is fragmented in terms of large number of small players in the market, but if we go to the import side, it's more concentrated compared to the local production. The concentration is in the market, it's relatively concentrated. If we look at the HHI index, which is estimated at 3,760, the CR4 and the CR3 is around 72%, 70% respectively. With regard to the prices, and contrary to the cases that we listen to, prices are rising in line with inflation, not with any unexpected spikes. Usually, seasonally in Ramadan, there is some spikes in the prices, but it's not different from other countries in the region. Now, the regulators, there is 4 regulators in the market: Ministry of Environment, Water and Agriculture, Ministry of Municipality and Housing, and Saudi Food Drug Authority, and the Ministry of Commerce. Moving to the recommendations as a result of this study, and then I'll move to the cross-border issues. I think the primary recommendation that we came up with the study is the importance of enhancing coordination between the different regulators in the market to ensure competition issues are considered and there is efficient market entry and expansion. Also, there is a recommendation from GAC perspective to have more advocacy rule focused on first analyzing the potential impact of regulations to ensure the competition considerations are incorporated, and second, to pursue a study on the informality and the impact of the informality in the public benefit marketplaces. And finally, support relevant authorities in designing least distortive support programs with transparent criteria. Finally, I move to the cross-border issues. As you know, and as I mentioned, reliance on imports with regards to agriculture emphasize the importance of engaging with different authorities, either in the region or globally, in order to ensure effective competition in the market. So that's why GAC is considering the scope of increasing cooperation with foreign competition authorities in 2 aspects. The first one, as a leading, we're taking a leading role in the Arab competition network. and we engage with our members in order to benefit from best practices in multilateral organization in order to find solutions for all the challenges that we are facing, including in the fruits and vegetable market. We have under ACN 4 working groups: merger and control, competition law enforcement, institutional efficiency, and policy advocacy groups. And we conducted more than 22 workshops, in addition to launching three competition awards in order to encourage research and development. And we will, since we published our study, we will have a workshop in order to explain the results of the study for our members.
Great, thank you. So before we move to the way forward, I briefly want to ask two people from the floor to come and share their perspectives. These are the Malaysia Competition Commission and the COMESA Competition Commission, both who've been very, very active in the ICN Special Project. So if I can start with Ms. Nabiha Mustafa from the Malaysian Competition Commission. You have a very interesting example, because here we've heard a lot of the market studies and inquiries and what's come out. You actually have a case of enforcement against, if I remember correctly, a feed cartel that you identified. Could you share just for 2 minutes briefly the experience you have and what you think we should be doing with this special project?
Thank you. So we actually conducted a market review, as Kenya is doing, on poultry feed back in 2014. Then we didn't know that we would use the information that we have obtained for our investigation that started in early 2022. So in late 2021, we noticed a spike of poultry feed prices in the market that also led consequently to the fresh chicken price in the market. And upon market monitoring, we noticed the market behavior is not as it's supposed to be. Then we started our investigations. We found 5 large enterprises involved in cartel in fixing the quantum of poultry feed prices. And these 5 enterprises have large presence not only in Malaysia, but also across the globe. But although we didn't take into considerations like how the impact outside of Malaysia, but I thought it would be good to also share that information. So in terms of what we can do in ICN, we think that it would be best if we have a sort of a database that what other authorities have done in agriculture sectors, because for instance, at the moment, my team is also looking at fish and vegetables. So instead of starting from scratch, it would be good to have something to refer to and also start conversations with other authority if they have cases that related to agriculture sectors, and we can go back to the data that we have and see whether perhaps similar conduct is also happening in Malaysia market. Yep, that's it.
Great, thank you. So a strong call for a database and an excellent example of enforcement of against a cartel. Dr. Willard Mwemba, who's the head of the COMESA Competition Commission. COMESA has been doing a lot of studies looking at problems in fertilizer, feed, poultry, vegetable oil markets. What are the cross-border issues that you're dealing with as a regional authority, and what can you do about it? Please join us on the microphone. 2 minutes, please.
1 minute was spent in walking, so 3 minutes. So thank you so very much for all the contributors here. Wonderful remarks, wonderful and insightful experiences. Thank you to South Africa and Kenya for being on the steering committee. Look, the issues of food are very important, and they cut across all territories, all geographic spaces, whether you're in the global south, whether you're in the global north, wherever you are, food is very important. So I think it's, in my view, it's the single most impactful project that would affect the entire planet if we all consolidated and galvanized our efforts into that. So that is the first thing that I'll say. Coming to your question, I think David has put it very clearly from our side. What we have observed, number one, is that there are terrible government policies. I hope I'll not be fired when I go back home. But there are terrible government policies sometimes that are implemented inadvertently, not knowing that they would have certain anti-competitive effects on the market. So this is what we've discovered from our research. This is what we are advocating for. We've been meeting different government players to try to change those policies. For example, import and export bans in Southern and East Africa, causing lots of problems for Kenya. Some of the small producers in the value chain, like in the poultry sector, even had to close as a result of those bans and skyrocketing feed prices in Kenya. Due to lack of import competition from Southern Africa, for example, that was having a bumper harvest for inputs that would be used to produce feed in Kenya. And then, obviously, I have a lot to say, so I'll be parroting here and there. Coming to the actual ICN special project, I would love to thank the volunteer countries, Hungary, Kenya, South Africa, Malaysia, Philippines, Brazil. Those that are forgotten, it's not intentional. We've demonstrated from what we've been doing the last 1 year since Brazil last year as a pilot project that if we come together, in fact, we can work together. From the experiences that we've shared, the research studies that have come from different countries, my call now would be to ensure that we move in the direction where we come up with deliverables. I think Malaysia said something like that. I would be looking for a toolkit. Someone, I think from the European Union earlier said, is it, or the moderator said, we may come together to identify problems, but we may have different approaches to those problems. So we may have all these problems in our different jurisdictions, our different countries, but maybe the time and approach to those issues may be different. What would assist us is to come up with some kind of toolkit within these countries that have volunteered, and obviously calling for more countries. Something that started as an African project under AMO, Africa Market Observatory. Karine, you've been involved, and Simon Roberts from the Center for Competition Regulation and Economic Development has actually gone out of that space and become almost a global issue now. So we are calling for more to join, and then the ICN itself, I think our clarion call to you is to make this project more of a structured project. I would love to see, to come to a point in time where I would see a proper working group on this ICN special project, because as I've said, it impacts all of us. So we will continue collaborating, we'll continue doing that. Thank you so very much.
Thank you. Okay, we are almost out of time, but this is the second part of our plenary with a few minutes left. What is the way forward? We've heard lots of ideas from you now, from COMESA and Malaysia. COMESA even proposing an ICN working group on food and agriculture, but more specifically this focus on a database, on toolkits. Can we hear from our speakers on what you think would be helpful in an ICN context to move forward to assist you in working on these issues? Let's start with Mr. Kamei from Kenya. It's working, it's on. Yeah, you don't have to turn it on.
Right. Thank you, Karine. The way forward. For us, I think boosting knowledge database or information database for all of us to link into for easier decision making would be ideal. So if we could actually invest in data and research, which is very critical, it would be very ideal to go that direction. Number two, we've talked about so many cross-border challenges and issues. I think we need to up our game in collaboration and cooperation so that we can tackle these cross-border issues if all are reading from the same script. I think lastly for us is that if we can review and advocate for pro-competitive policies and regulations in our different jurisdictions and under the umbrella of ICN. Then it will be possible to tackle any complex challenges that we may have, not only in the food and market industry, but in all industries. Thank you very much.
Excellent, great ideas. I'll just pass on to Saudi Arabia now.
Thank you, Karen. I think, having best practices is important for future work of each jurisdiction. Therefore, I would suggest that basing the future work of this project or any other project on best practices that we develop based on experiences either from emerging developing markets or advanced markets. That's the first thing. Second, I think engagement at the beginning of the market studies with other jurisdictions is important in order to learn lessons in terms of scoping the studies and also learning how to conduct these studies and develop the recommendations going forward is very important. Thank you.
Thank you. Hungary.
I believe we should move towards creating and sharing short case studies that illustrate practical experience, challenges, and the ways other authorities tackle them. Alongside that, publishing toolkits and methodological recommendations would be very valuable. These would provide concrete guidance for authorities facing similar issues and would have built a more coherent and practical body of knowledge within the ICN community. Thank you.
Excellent, thank you. And last but not least, Australia.
Thank you. I strongly support the database suggestion from Malaysia to assist in each of us in a cooperative sense, but two elements that I would like to see in it. And the first, in relation to data, is looking at the sources of data and the methodologies applied by our data teams in order to analyse and determine the levels, for example, of competition, concentration and margin at the different levels of the value chain. And the second, picking up in a sense the short case study concept, we have global players here. The traders manifestly also in a number of cases processes. And if in the description in effect of the case there can be a very brief description of the conduct that is seen, particularly if there are restrictive practices that have been seen, it is likely global players will, in a sense, apply similar strategies across the world. And so noting either restrictive conditions, a pattern of serial acquisitions or cripping acquisitions, it will help alert each of us to the sort of points that we should be watching out for.
Great, thank you so much. There are some very concrete ideas that have come out of this session. I think your last presentations were very clear. I think there's pretty much agreement here on a database, and I think thank you to Ms. Cass-Gottlieb for being a bit more specific about what we want to see in this database. The sources of data, the methods for how information is being collected, so that that can help inform some of the cross-border issues and challenges that authorities are facing. There's been a strong message around toolkits, best practices, case studies, all also contributing to this methodological challenge, but again, helping countries to see how others are doing it and to see how players in their own market might be acting in other markets. And then lastly, we have this call around policy that's come out quite a lot, and making sure that we don't forget this policy advocacy piece and how you deal with when it's the policies that are driving the concentration or the anti-competitive conduct. Thank you so much to our speakers. Thank you to the ICN and to the CMA. And I think it is now moving to the next session. So thank you. The coffee break, right? Yes.
Good afternoon, everyone. We want to start. Some will find us on the way. My name is Doris Tsepe. I'm from the Competition Commission of South Africa. We have an exciting afternoon, and I'm hoping after the tea break, you've had some coffee and some vanilla cake to keep you awake. But I can assure you the team I have here is going to rivet you, and so you will still be around. I have with me a group of enforcers who will be speaking to us. I'll start with Hara, who is the Vice President of the Hellenic Competition Commission, Rasul Bat from the Competition Commission of Hong Kong, and Diego Solano, who's the Chief of Advisors for the Protection of Competition and Superintendent of Industry and Commerce in Colombia. And then, of course, we have Wangombe Karaoke, who is an NGA of the Competition Authority of Kenya, who used to be the DG of the Competition Authority of Kenya. Thank you and welcome. Just some opening remarks from me before I hand over to the team is that we all know that a country's competition legislation sets out the mandate and powers of competition agencies, but the effectiveness of the law in achieving that mandate depends on the agency effectiveness of the use of these powers. In the current economic environment, there is pressure on agencies to be more effective with the resources and the powers that they have to achieve the objectives of improved competition and competitiveness to assist in economic growth and innovation of our jurisdiction. This is in the context of increasingly complex and dynamic markets that require agility and a range of tools to bring about more competitive outcomes. This plenary will explore two themes in agency effectiveness. The first one is, whilst many agencies have looked to legislators to expand their powers to address the current challenges, very often agencies are not making optimal use of their current tools. This includes not just the hardcore powers, but the soft law powers as well. And secondly, the second theme we're going to look at is, whilst better use of existing powers can improve agency effectiveness, some of the competition laws are dated and were developed in a very different economic context and may not be responsive to the challenges faced today. And this may require an expansion of some of these powers or tools available to agencies. I'm going to start with Wangombe to start and give some opening remarks. You have some couple of minutes to do so, Wangombe, and then we'll move along. So if you could, and welcome.
Thank you, Doris, and thank the ICN for inviting me to participate in this plenary. And Doris, from what you've said is from where I sit. I see a conundrum of how competition agencies, they are trying to deal with the issues which they are facing in the enforcement mandate. One is that I see, as you have indicated, countries which are moving towards amending their laws and expanding what I may call their compound in terms of dealing with emerging issues. And then on the other hand, I'm seeing another class of countries which are dealing or even interpreting the laws they have purposely to deal with the situations facing them. I've seen, for example, South Africa dealing with digital economy issues using their market power provisions without amending their law. Yet also I've seen some countries with their market power provisions still pushing for the amendment of their laws in order to deal with digital economy. So there's that, what I'm saying, there's a conundrum which is coming out. Also, I've seen some countries which they don't have the regulatory capacity within their laws, but they are using other laws within their jurisdiction to deal with the emerging issues. And if at all I'm not wrong, I've seen in Nigeria the FCCPC using their constitution and other sectoral laws to deal with the matter they handled the other day. I'm not going to discuss the decision, but at least that was quite an effective way of approaching issues. And now coming down to where I come from, the Eastern and Central Africa, Kenya, I saw, for example, that one dealing with an issue where they created a provision of abuse of buyer power, aimed at protecting the suppliers. And there are so many questions in regard to how does a competition agency come into managing individual contracts. And within a very short time, South Africa picked it up. In terms of enforcement of that law, I think it's a matter of which we should be discussing after 2 years, because there has been some precedent cases where judges have said the implementation is bordering on constitutional rights of some of the players. So even when we are undertaking, as regulators are undertaking some powers, they should be tempering their ambition and overzealousness in terms of limiting them within the other constitutional obligations that they have. Then the other issue in terms of the powers, I've seen what I may call in terms of proportionality. Our host yesterday, Sarah, mentioned about proportionality. Where I come from in this part of the world, we always say you don't respond to a mosquito bite with a hammer. So, if at all you have a situation facing you, it does not necessarily require you to amend the whole law, and yet you have not, covered the ground you have. For example, when we have this issue of digital markets, I've seen 2 countries in Africa where when they were creating their law, they have economic dependence provisions. They have never enacted them, and they have never implemented them. And yet we have others yearning for the enactment of those provisions. Then in terms of also proportionality, I wanted to bring in the issue of penalties, where I've seen some overzealousness in terms of pushing towards 10%, and it's in terms of the harm. Whereas we have 2,600 suppliers supplying one buyer, and it's only 2 suppliers who are affected, and then you impose a maximum penalty of 10%. So that's another power which you have responded to a mosquito bite with a hammer. In terms of also public participation in coming up with those laws, I think we need to improve on the quality of the public participation, and also sieving what we receive from the stakeholders and implementing what I may call optimal regulatory regime, rather than rushing into implementing what we can't implement, and yet we have not implemented already what we have. Let's deal with a situation where we are not increasing the pages of the laws we have, but rather dealing and achieving our mandate. Thank you very much.
Thank you so much. I think we need to heed to that warning. Is we have tools currently. Can we try and see where we can effectively use them before we start to venture into knocking on doors of legislators? Thank you very much, Bangome. I will now turn to Hara and hear what your experiences have been in Greece. Thank you so much.
Thank you. Thank you, Doris. You're very right in saying that we need to look at our tools. I think that this was also stated earlier today by the head of our hosting authority, Sarah Cardell. She said we need to look at our tools and say that and look at whether they are still relevant, and we must use them with effectiveness. In our authority, we have a variety of tools to use. We have, of course, traditional enforcement, but more and more we have been using other tools. You might call them softer tools, in order to ensure a timely and effective enforcement application of competition law and policy. So one tool that we have been using quite a lot is mapping. Mapping, as the word says, means mapping markets. We look at the structure of markets and the behavior of companies within a certain market or a sector. And this might lead to various results. This is a very, very flexible tool. So what might come out of this might be that we do not need any further action, and therefore we publish the results. We had done a lot of mapping in the food sector, and sometimes we saw that there is no anti-competitive behavior that we need to look into via enforcement, but there may be issues of, for example, consumer behavior, cognitive biases, asymmetries of information, decision fatigue, and consumers keep on buying more expensive products. We then publish these types of inquiries, these types of mappings, to inform consumers and to raise awareness about what is happening in the sector. So mapping has been used a lot. In food, they might lead us to further action. For example, we looked at foods. We saw that a large part of the cost of producing food is animal feeds. Another large part of the cost is veterinary medicinal products. So we tried to look at that sector too, to try to actually find out what is the reason that food is on the shelf is getting more and more expensive. So this is a very flexible tool that allows us to look at market structure, to look at behaviors, and decide on our next action. Our next action might be to publish it, as I said. It might be to go further into a sector inquiry and lead to specific proposals to the government for legislation or to businesses for best practices. So a recent mapping that we did was in the coastal services, and that led us to launch just yesterday a sector inquiry, because we saw that there are issues in the structure of the market that we need to further inquire that might lead to concrete proposals to change how this market is designed and how it is worked and how it is supervised. So we have mapping, which is, as I said, flexible. We have sector inquiries. Sector inquiries have been used in all sorts of industries, from savings to fintech to e-commerce to supermarkets, waste management, health services. And they have an added value that they allow us also to engage with all stakeholders. We publish the first result of our findings. We issue a public consultation. We listen to the opinion of the business community and of consumer organizations, and then we take this back and we come out with a proposal that has incorporated their views on this issue. We also have another tool, which is, we call it the regulatory intervention. This is a tool that we might use when there is no reason to intervene based on we don't have an anti-competitive agreement or an abuse of dominance, but we see a behavior in the structure of the market where we need to intervene and adopt certain rules for the entire sector. It's very, very similar to what is currently discussed, the new competition tool, as has also been proposed in the much discussed Draghi report. So we've used this in the petroleum industry, we've used it in the press distribution sector, in the construction sector. We're actually using it again at this moment in the petroleum industry. What we saw was that there is a delay in the pass-through of price decreases and a very timely increase in pass-through of prices from refineries to wholesalers and then to retailers. So we launched the regulatory intervention to see what's happening. We're going to be publishing our results later this year. So these are various tools. This is what I want to say. These are various tools that are beyond traditional enforcement that allow us to intervene in a very timely manner to see what's happening. They might lead to a case. They have indeed led to cases that then take on the road of traditional enforcement, but most of the time they allow us to inform the public of what we've seen. They might lead to some type of intervention from the government, the adoption we hope, of better business practices from companies involved, better knowledge sharing with consumers about their own behavior and what they can do to make their own choices better.
Hara, thank you so much. And I think what I find very useful, particularly with your mapping tool, is you using that as a mechanism for further intervention as well. So it's not just as a market study of understanding the market, but what else can you do in better investigation? And we've seen that that works better, especially when it is properly planned. I'm now going to turn to Rasul and just ask you if you could just give us your experiences in Hong Kong. Thank you.
Right. Thank you very much, Doris. First of all, if I may express my thanks to our very gracious host, the CMA, excellent organization, amazing hospitality. It's always great to be here amongst our fellow enforcers. So this year actually is a special year for the Hong Kong Commission because it marks the 10th anniversary of the full implementation of competition law in Hong Kong. Under our competition law, the Hong Kong Commission has been vested with a range of powers, which are, I think they are generally very similar to the powers that other agencies have. For example, the power to compel undertakings to provide information and documents to us, the power to conduct dawn raid. But when we talk about tools, it is, of course, not confined to statutory powers because over time, agencies, they do develop tools which can help them optimize their resources as well as to enhance the effectiveness of their work. So today, I would like to talk about a new tool which the Hong Kong Commission has been using, and it takes the form of our strategic partnership with other law enforcement agencies in Hong Kong. For example, the Hong Kong Police and our anti-graft agency. So yesterday, I was listening to Kani of the Spanish Authority. I understand that the Spanish Authority have been collaborating with their local anti-graft agency. And today, I heard Nuno at the Portuguese Authority talk about doing joint dawn raids with their police. In Hong Kong, we have been doing both. Now, why do we collaborate with other local law enforcement agencies? Because in Hong Kong, particularly in a number of our major investigations, we do see there is some interaction between competition law and criminal law. For instance, we have seen anti-competitive conduct being perpetrated by organized crime syndicates in Hong Kong. And these people, they have no qualms in using criminal tactics to achieve their goals. For example, in order to win a tender, they would intimidate their competitors to stay away or to join them. And if these competitors do not play ball, they may be facing some criminal intimidation, physical harm, and damage to properties. Now, sometimes there are also involved some giving and receiving of bribes, which may be used to coordinate and maintain bid rigging and price fixing cartels. In order to effectively deal with this type of cartel, I think it's very difficult for a competition agency to go it alone. We need to take a concerted effort and work with other law enforcement agencies. Apart from there being interaction between competition law and criminal law, another reason why we collaborate with other more established law enforcers is because we can leverage on their vast resources. I'll give you a very quick example. The Commission has conducted a dawn raid on one of the biggest wholesale fish markets in Hong Kong. Now, what is special about this fish market is that it is reputedly controlled by a major criminal organization. So when we conducted dawn raid, I was sending 30 of my investigators into the fish market. But as you can imagine, I'm sending them into a potential hostile environment. So what we did was we sought help from the Hong Kong police force. And to assist our dawn raid, I sent 30 of my people the Hong Kong police force, they provided us with 150 police officers. And these police officers, I have to emphasize, they are not ordinary police officers. These are specialists in dealing with triads, in dealing with gangs. So as you can imagine, the dawn raid went about very peacefully. Everybody were in their best behavior. Now, if I can now quickly talk about our cooperation with another agency, which is the Anti-Corruption Agency in Hong Kong. Now, with the Anti-Corruption Agency in Hong Kong, we have conducted 2 joint raids with them. And we targeted suspected cartelists engaging in both anti-competitive as well as corrupt conduct in projects involving the renovation of residential buildings. For those of you who may have visited Hong Kong before, you will know that the majority of people in Hong Kong, we live in high-rise residential buildings. It's multiple ownership, and a fun fact about these concrete residential buildings, there is actually a limited lifespan of around 50 years. So it is important for the owners of these buildings to maintain these buildings. They have to do building maintenance work, but the cost of doing building maintenance work is quite a lot. Just to give you a rough idea, it costs each household around maybe $7,500 US all the way to maybe $35,000 US to do renovation work, and this is just what one household have to pay. And you are talking about a multiple ownership building with hundreds of households. Multiply that in the hundreds, we are talking about a lot of money. And with the Anti-Corruption Agency, we managed to do 2 joint raids with them. We have the ICAC, the commission, they have arrested about 20 people. These 20 people are suspected to be mastermind and backbone of a cartel, price fixing and bid rigging cartel, who have also been providing bribes to different parties. And also after we did the first dawn raid, we went on to do another dawn raid, because as it often happens, when you do the first dawn raid, you think the scope is like this. After the first dawn raid, you realize the scope is actually much, much bigger, which is a happy problem. And in the second dawn raid, we discovered that these cartels may have been involved in cartel activities which cover about 38 residential premises. If you talk about the value of the renovation projects, we are talking about $128 million US, and with the value of individual contract costing about $34 million US. So we are talking about a lot of money. We managed to do 2 dawn raids, very successful dawn raids, and I think we have gathered quite good evidence which we are working on, and hopefully in the near future we will be able to bring a case before our competition tribunal. I'll stop here.
Thank you so much, Rasul. I mean, I think you're raising very important points, and we've been speaking about collaboration as in mostly interjurisdictional collaboration, but in fact there is collaboration even amongst other agencies or amongst other regulators. And I know that there was a breakout session where we were talking about collaboration between regulators and sector regulators and competition authorities. So thank you very much for that. We will get into some of the detail in a question and answer session, but I just want to get Diego to give us what they've been doing in Colombia and how they are dealing with the issues of agency effectiveness. Thank you so much, Diego.
Okay, thank you, Doris. First, I'm very glad to participate in this panel, and so many thanks to the organization for the support that we received from them. They were really useful, especially to the Secretary and the Co-Chair of the AEWG. There is a general idea of creating or generating new tools to face new market dynamics. In Colombia, we believe that with the current tools, we can adopt them and to face, just to switch. I mean, to face these new problems that are emerging in the market. In our case, this reinvention of the traditional tours starts also with the down raise, and also with a second mechanism that we haven't developed in the past, but we started developing last year, is related to the interim measure or the injunction relief. It accompanied, it means it's joined with the down raise. We identified that in the cartel cases, the people want a rapidly response. So I'm going to explain a case that we identified the last year. We can do down raise, and we get the result just in 3-4 months in an international event. That it was really effective. That implies collaboration between different authorities and with the competition authorities. And in that case, for example, we add some positive injunction and also cease and desist order. So this was a really good example, just not to wait all the period that take the investigation. Maybe in our jurisdiction it will take like maybe 2-3 years all the process. So we are getting resolved in a preliminary stage. So this is a really good way that we found to resolve and to respond all the problems. We also prioritize some sector that is strategic for us. So we are implementing, for example, the exception block extension in some strategical sector like agriculture, that we identified that the government want to prioritize the sector, and also so we identified that different way that they join, avoiding to have effect in the competition and to join forces. There is a good way to increase their benefit in the food sector. Finally, I would like us to just outline the importance to collaborate between authority and regulators. There is a huge change in our policy in energy, oil and gas sector. Just the last year, I think it was like almost 60 modification of the regulations. So we are working together, I mean, just to understand what are they looking to face, what are the problems that they identify, and just all the process to the most like healthy or to energy that not can impact like environmental high impact.
Thank you so much, Diego. I'm going to then, I think, go into some of some questions with the panel, but I'm hoping that there will be scope for the audience to ask a question or two to the panel, but let's see how they do in managing time in this first rounds of questions that we have. Wangobe, I'm going to start with you. I mean, you know, jurisdictions on the African continent typically have mandates that extend to economic development objective. How effective have agencies been in implementing this mandate, and how could they improve their efficacy given the existing powers and tools that we have? You've spoken a little bit about this, but I just thought if you could expand, and we're listening very attentively. Thank you.
Doris, you're putting me in a very tight corner in regard to telling me to audit the way jurisdictions have implemented their mandate. But what I can say is that in Africa, I've seen a lot of growth in terms not only of the caseload, and also in terms of the expansion from mergers to cartels. And then we are seeing some visibility in abuse of dominance. So I can say, even if I'll not give them 100%, is that there's some progression in terms of enforcement. But also is that they have been facing some challenges in terms not only of the dynamics in the market and the emerging issues, and also to try and deal with the challenges facing their constituents. Because the position I have is that all laws are made to attend to the problems facing each country's constituents. And a competition law is part of that instrument. And that is why we have seen competition agencies coming up with expanding their powers to attend to those emerging issues. But my main concern, Doris, it's in regard to how do we expand the regulator's powers, but within some checks and balances. What triggers an amendment of the law? Should we have a specific threshold in terms of, the level of commerce which is being affected? If it's something just affecting 1% of the population in South Africa, should we trigger an amendment of the law? Or if at all it's only one case, a small case, which we have failed to attend to, should we trigger an amendment of the law? I think those are the questions we should ask ourselves. And then when we trigger that amendment of the law, how do we bring on board all the stakeholders so that they can inform the process? And then after that is that I would wish the African competition agencies also they can regulate with what I may call side mirror regulation. Look at the dust you are creating so that you don't just regulate, especially the dynamic markets, and move on. It's always good to look at the impact of your decisions. And then that is when we can see whether our implementation is achieving the economic development agenda of our constituents. That is the challenge I would throw.
Thank you. And you speaking here of impact assessment, for example?
I'm speaking of impact assessment. That's what I'm calling it.
Yes.
Let's regulate through the side mirror.
Okay. All right. Thank you. Just on that point on threshold, it sounds very complicated. I mean, part of the reason often most jurisdictions do not amend their laws is and look for regulations which are subordinate legislation in a way, is that the process is so it's very complex. I mean, in most jurisdictions, what threshold are you talking about? I mean, is that adding to another layer of processing on amendments, especially where you require agility if you're looking for an amendment on digital markets or to implement on that? Wouldn't that almost cause some difficulties for certain jurisdictions?
When I talk about the threshold, when do you turn on the tap? Is it when you have just failed to deal with one small case in one part of the country? Or it's a major case which cuts across the whole country? Not that I'm giving an answer, I'm just giving an array of ideas. Or is it when you do a market inquiry, which is just affecting people in a certain high-end estate in Nairobi, or it's something affecting the vulnerable members of the community across the whole country? That is when you turn on the tap to amend the law. So that is the kind of threshold I'm talking about. The number two, I know the legislative process in some countries is quite tedious. And when I revisit how the easiest way to deal with it, it's when you focus, like for example, you can approach the Ministry of Finance or Treasury when they are proposing their budget proposals, and then the amendments can become part and parcel of achieving the government agenda for that financial year, and that can facilitate the amendment of the law. I think it's just looking at windows where you can push an agenda.
Absolutely. It's prioritization given the limited resources we all have. Thank you. Hara, I'm going to come back to you on the use of this range of soft laws. I mean, I find that very interesting because we could make better use of these soft laws that are available to us as non-enforcement tools, but these are tools that would help us achieve our primary mandate. And I just wanted you to elaborate a little bit more on some of the examples where you have done this in Greece and how you have implemented that. Thank you so much.
Well, these tools are not all very, very soft. So, for example, a regulatory intervention is not that soft. But we have used these in a variety of sectors. We have, as I said, we have mapping inquiries into food, into detergents and dairy products. We saw that, for example, we need to look further into the food value chain, and we did further inquiries into this. We look at the banking sector, fintech, e-commerce, waste management, health services, petroleum industry, press distribution, construction, a lot of industries that we've been doing these types of inquiries. But if I have just 1 minute, I would like to say something on what has been said before about amending our tools and what we have. I think that it goes without saying that any amendment has to be done with extreme care. A qualitative and quantitative analysis has to proceed, has to be done before we proceed with any type of amendment, and obviously an assessment of whether the authority has the resources to be able to live up to any new powers that it may have without risking its traditional enforcement and the course of its job. And another element that I think we need to consider is whether any new powers in general would risk our independence or risk the need to be accountable for what we do. So I think that it's of course always an open question and an open issue whether we need to add to our toolkit or use the toolkit that we have in a much better way. But what is for sure in my view is that whatever move we make, whatever proposal we make, it needs to be done with a lot of care and taking into consideration a variety of factors.
Thank you. I was actually going to ask you on this expansion of powers, more what types of expansions you have in mind, because I think, and this is more in what are rapidly evolving markets, and if you could just elaborate a little bit on that. Thank you.
Thank you. So I might say what has been happening in Greece, in our jurisdiction, and one expansion of our powers to a type of unilateral behavior that's quite recent. It was introduced about 3 years ago, and we have ongoing investigation, but we have no decisions on this yet. And it's a provision in our substantive law about the prohibition of invitation to collude and announcements to communicating future pricing intentions. So it's about invitations to collude and about price signaling. So this is a type of unilateral behavior, probably between anti-competitive agreements and abuse of dominance. It applies to companies of a certain size, so above 250 million, 50 million euro, turnover, and more than 250 employees. What it, in essence, this provision says, and we are called to enforce it, means that it's prohibited to invite another undertaking to participate in an agreement. This will probably be done privately, but they don't actually reach an agreement. There's just this invitation to collude, and also the disclosure of prices that are of information that is relevant to prices where this might hinder effective competition, and it's not usual business practice. So this is price signaling. Of course, we have to look at the nature of the information that's been disclosed, whether there's a history of collusion in this industry, and a lot of details. As I said, we do not have a decision on this yet. We have investigations, but I think it will be quite interesting to see how this is applied and how the courts, who will most probably review any type of decision that we may come to, will look at this.
Thank you so much, Hara. I'm just going to go back to you, Russell, and as I said to you, just to elaborate, I mean, you have identified certain challenges, I think, with collaborating with other agencies. I just wanted you to just speak a little bit more on these challenges, and how do we improve on this to make sure that these collaborations actually are more effective?
Thank you, Doris. As I mentioned, we just celebrated the 10th anniversary of our...
Yes, congratulations on that.
Thank you very much. So we are collaborating with other law enforcement agencies. For example, the Hong Kong Police has been around forever. The Independent Commission Against Corruption in Hong Kong, they have been around for 50 years. So when you collaborate with these longer established agencies, initially, of course, there'll be some skepticism on their part. You know, okay, this new kid on the block want to collaborate with us. Do they know what they're doing? What is competition law even? But what is very important is, at the outset of talking about cooperation between us, we need to establish the fact that it has to proceed on the basis that we are equal partners. That is very important. And in order to do that, the first thing is we need to build trust with these longer established agencies. And I think, in my opinion, there is no better confidence building and bonding exercise than doing a dawn raid together. I think that is very important, because the way you plan out how to do a dawn raid, how you execute dawn raid, what you can bring to the table, whether you are a competent agency, this will show up during the dawn raid. You will either make lifelong friends during the dawn raid if you do it well, or you make lifelong enemies if you mess it up. So far we have been making very good friends with other agencies, so I think we have been doing quite well. Thank you.
Yes, I think it was Andreas yesterday. He says, if you demonstrate good outcomes, you will definitely make good friends. So thank you, Russell. Diego, I'm just going to come back to you and just on the expansions of tools for agency effectiveness, and whether we do require changes to the law, but whether that can include technological tools to improve investigation and some of your analysis. Has Colombia leveraged some technology to improve effectiveness? I think from our discussion, you seem to have some interesting tools that you're using for these purposes, and if you could just share with us your experiences.
Yes, thank you, Doris. Yeah, we have just developed two tools. One is going to, we're trying to improve it. The first one is just related to the procurement, public procurement, to detect and to deter some alerts in this public procurement. They have for example, we analyze all the public portal of the tenders, and we detect 3 or 4 elements in that platform. One, for example, it shows a red alert where is a constant tender, or is a constant contractor in this process. So it's not usually that always the same person win all the bid. And the other one is related to the budget and the final value of the contract. It is similar or just a difference between 2 or 3%. There is another alert there. They analyze the platform and they show us the result. And that is basically the 2 alerts that we are trying to improve this tool. The other technology that we use that is really useful is an advocacy function. It's not, I mean, in the enforcement activity, but it's really useful for us because, I mean, when we have like a recent ex officio function in Colombia that we have to give all the, to get the advocacy in the regulator's draft. So, but it just for the 4 years, I mean, the last 4 years that it was an ex officio. So we have to check all the website. And now we create like with an AA tool to identify all the draft. They show us the potential draft that it will affect the competition. That I mean, we save resources and people just, I mean, the lawyers and the economists just have to analyze the draft and not to check in every day the website. And yeah, it's really useful for us and to save time.
Thank you so much, Diego. I think we may have time for 2 questions from the audience. Hopefully they are not long questions. I think we have some 10 minutes for that. And so if I could see a show of hands from the audience, I did promise that I wanted this to be a little more interactive. So if there are some 2 questions, we would really appreciate it. I'm not seeing any hands. Oh, there are, yes. Please, thank you.
Hi, thank you very much for the presentation. It was excellent. My name is Athanasia Gavala. I'm from the Hellenic Competition Commission. I have a question for Azul from Hong Kong. I mean, the discussion about the collaboration with the police and the other agencies is very interesting. And I have a practical question. Is there a legal framework for this type of collaboration and joint conducting of dawn raids, or is it something that you do informally?
Thank you for your question. Now, in terms of our collaboration, for example, if I can use our collaboration with the Hong Kong police as an example. Now, we have 2 different kinds of collaboration with them. There are cases where the commission is the one which conducted dawn raid because the case only concerned competition matters, but just so happened that that particular case involves some criminal elements. For example, a bid rigging case, but the bid rigging is perpetrated by a organized crime syndicate. So in that particular situation, what will happen is we are the ones who go to the High Court to apply for warrants, and we will conduct the dawn raid. What the police does is to provide us protection and assistance. So that's one type of collaboration. But earlier on, when I talk about the collaboration with the anti-corruption agency, now that dawn raid is a joint operation because not only does the case involve competition contravention of competition law, bid rigging, it also involves corruption elements, someone offering and someone receiving bribes. So in that particular case, it was a joint raid. But to conduct that dawn raid, what happened is both agencies, we apply for our own warrants from the courts separately. So, I mean, there have been some people saying, okay, trying to challenge us, is there any particular legal framework for it? Our answer is very simple. We conduct our dawn raids within the ambit of the warrants which we apply. So if you think we have exceeded that, you're welcome to challenge us. Thank you.
I think Wangobe wants to respond also to that. I think he's had some of experiences in this regard, please.
Yeah, when I was on your side, we had a situation like that. The Kenyan law allows the competition authority to collaborate with any other government agency when it is conducting investigations. But also is that you have to be aware of the challenges in terms of managing the confidentiality, depending on how the other agency may have infiltrated. That is one thing, and then the other issue in terms of also governance issues when you interact with the other agencies. I'm talking from my experience within the region I come from. But as you indicated, it's an issue of mutual trust.
In fact, in South Africa, the Act allows us to enter into memorandum of understanding with other regulators and agencies who can help us. And it is there, Wangome, where you would have all these issues, including confidentiality, on how best to deal with them. I have still a couple of minutes, and I saw some members entering now, and I wanted to know if there are any more questions. If not, I'm going to allow my panel. Is there a question? Oh, yes. I see another hand. Thank you so much. Go ahead.
Thank you very much, and good afternoon, and very wonderful discussions. My name is Parrot from the Zambian Competition Authority. Just wanted to ask the panel, in as much as collaboration happens with other law enforcement agencies, do you think it would be appropriate to also train officers of the Competition Authority in some kind of defense mechanism, just for self-awareness? I'll give you an example. One instance where we were doing a dawn raid, we went with the police. During the dawn raid, there was fire on the back of the building. And because we didn't know what to do, we left. And that case was botched. So is it appropriate that we give these officers some level of situational awareness training?
That's a very interesting question, and I'm going to leave it to my to Rasul. I think you'll start first. You've had more exciting dawn raids, it sounds like. I will send it
Quite exciting dawn raid. Actually, my head of enforcement, Patrick, is here today. Now, we do provide training for our staff to conduct dawn raid. The thing which we find very fortunate is that even though we are a new competition agency, it doesn't mean our officers lack experience, because we have been able to recruit a lot of our investigators from other law enforcement agencies. So quite a number of our colleagues are from the Hong Kong Police Force and the Independent Commission Against Corruption. And, you know, in their previous agencies, they have received a lot of training. But of course, once they transition to the Competition Authority, we need to make some adjustments. But, and in some of our dawn raids, we have also encountered situations where we encounter obstructions. Now, this is an area where we have to handle very carefully, because they are no longer police officers. They are no longer officers of the anti-graft agencies. So that's why when we plan to do these dawn raids, we always anticipate whether we may encounter such resistance from the parties. And if we anticipate that to be the case, then there may be situations where we would have asked for the assistance of the police force to be there with us to help us deal with those situations, instead of asking our staff to deal with it.
Yeah. And I think what you're saying, Rasul, is that planning and preparatory work for dawn raids actually is quite key in these situations. Kara, I know you want to add something onto that.
Absolutely. Training and planning and preparing for dawn raids is necessary. I would not go so far as to say we need to train them for physical defense, but obviously to be ready to conduct the dawn raid effectively, that is the result of training and preparation. I just wanted to stress one more thing that I think is quite important. Rasul just mentioned it, to be very, very vigilant when it comes to obstruction of dawn raids. And we've had a few examples in Greece in the last few years where we've been very, very strict, imposing very large fines on natural persons and on companies for obstructing our dawn raids. And I think that this actually sends a message that we expect and we will not accept anything less than absolute respect for our people who are out there working probably beyond their normal working hours and giving every effort to conduct an effective dawn raid, and that anything other than this will be prosecuted and punished if the case be. So I think that cases on obstruction and being very strict with this actually help effective dawn raids.
Thank you so much, Hara. I think I'm going to ask for closing remarks from each of you. And Diego, I'll start with you, and then you can answer that question and give your closing remarks. 1 minute each. Thank you.
Okay, thank you, Doris. Yeah, I have experience in down raids. I mean, it is quite difficult to conduct all the down raids. I practice like a 15 or maybe 20 down raids in my life. It's the hard part of the job, but it's the crucial tool for all the competition authority. I think that it's, I mean, the first like a 20 or 1 hour of the down raid is if you know if the case is gonna be to be successful or not. We support with the general attorney like in cases of involving collusion in public procurement, for example, because in Colombia the administrative, I mean the model that we can force the down raid. So if they deny the access, we have to stop the down raid. So we focus on the topic that Hannah was mentioned, that the obstruction function. I mean, the last year we sanctioned maybe like 20 companies that deny access to the computers, to the cell phones, I mean, to the business information. So it's a really good way to complement the function and to be susceptible of the down race.
Thank you so much, Diego. Rasul?
I think my last remark is, I think when it comes to collaboration with other, whether it's other competition agencies or whether it is collaboration with your local law enforcement agencies, of course you can come up with MOUs. I mean, there are a lot of MOUs around, but I think it is more important for us to have real opportunities for us to work together, you know, in practice, so that we can build trust. Because there is, I mean, you can have everything written down in the MOU, but if you don't put it in practice, it doesn't mean a lot. Yeah.
Thank you. Well, I think that as a final remark, I think I would say that we have talked a lot about a lot of new antitrust powers, expanding what we have, making what we already have more effective. And there's a lot more that we can talk about. Maybe it could be the subject of another a plenary session on agency effectiveness. We didn't touch about the need for a digital evolution and to make use of these incredible powers that technology has been given us. This is the evolution and the augmentation of the powers that our people have and that our current technological capability gives us. So when thinking about our tools, we cannot leave out of the discussion the tools that digital transformation and digital evolution can give us. And I think that this discussion and the different ways in which we all see what these tools are, human tools, digital tools, collaborative tools, new substantive tools, shows the breadth of ways in which we can make our work more effective. So this is actually one of the greatest things about being part of this fantastic network.
Thank you so much, Hara. I will go to Wangobe.
Thank you. One of the critical fundamental thing of an effective agent is creation of certainty. And as you expand your regulatory boundaries, I think also it's important to come up with resources, whether human capital and skills, so that you can be able to effectively implement that mandate. When you have a big mandate and you're not implementing it, it creates a lot of uncertainty to the business community in terms of there's an armory there, we don't know when it's going to be opened. And also is that when you have expanded mandate and you don't have adequate human capital to be able to bring up critical optimal decisions, you are going to have a reputational risk, because any suboptimal decision you take, it affects your reputational risk. Thank you very much.
Thank you so much. I think we need to give my panel a round of applause, but just before we do that, just to confirm, we've spoken about a number of things. The first one is that we have powers. We need to use existing powers effectively to be able to achieve a mandate. There may be instances when new powers are required, and when those are required is to assess, to make the assessment. What is that threshold that you spoke about earlier? But collaboration as amongst agencies, but collaboration with other agencies which are not competition agencies is quite key and effective in making us achieve this. So if I could ask all of you to give the panel a round of applause for all of that. Thank you very much. And may I ask that no one leaves yet? We are about to start with the World Bank Awards, and I'm going to invite Andreas Muntz to the podium to start with the Advocacy, ICN World Bank Advocacy Contest. Thank you so much.
Eleanor, hello. Well, dear colleagues, dear friends, many thanks for staying with us at this late hour in the afternoon, but this is an important part of the conference, the annual, the advocacy, the competition advocacy contest, and it is really important, and I always would so much like to win a prize. I do not know if it works this year, but we will see. I am grateful to announce the 11th edition of the competition advocacy contest. Don't get confused. If you look at these prizes, there is a 12 in there. So in fact, it's the 12th contest, but it's the 11th contest together with the ICN and the World Bank. So that explains this a little bit of a difference. You might all know that competition advocacy has always been a key pillar of the ICN. And when we started the ICN, initially, we had 2 working groups, and that was not on mergers and cartels. No, it was on mergers and advocacy. And you can see from that from the very start of the ICN, advocacy played an enormous part in the work of the ICN. And I think as of today, it is even more important since we see all these geopolitical dynamics. In many parts of the world, we see an increasing pressure on competition agencies, on their independence to a certain degree. And this is why I believe it is always of so great importance to make clear to policymakers that competition shall always be a part of their solution package whenever it comes to any economic crisis or any economic different situation. I would like to thank very briefly today everyone who is contributing, who has contributed to this ongoing contest, a contest that is held by 2 organizations, the ICN and the World Bank Group. This year, the contest looked at stories that demonstrate the tangible results of competition agencies in 4 categories. The first category was supporting resilient and competitive value chains to enable private investment, jobs, and consumer welfare. The second was embedding competition principles in policies to manage state assets, SOEs, privatization, and public-private partnerships. The third was enhancing public procurement and curbing bid rigging for government savings. And the fourth was advancing competition through public-private dialogue. My special thanks go to the competition authority from Italy for organizing this contest on behalf of the ICN. My thanks go to the World Bank for cooperating with the ICN, and I would like to thank both of them, maybe with a little round of applause for this dedication. I would also like to emphasize that this award also demonstrates the importance of working with NGOs, because every year Eleanor Fox, who is with us here, and Mariana Tavares, they both contribute to this contest, and I would very much like to thank them for their thoughtful and rigorous contribution to the evaluation panel. Eleanor, Mariana, thank you so much for that. So, this is already the end of my little introduction. Although we are waiting for the winners now, my congratulations also goes to everyone who is going to be happy to hold one of these prizes in their hands in a couple of minutes. And having said that, I hand over to whom? To the Italian Competition Agency, my friend Roberto Rustichelli, and my friend Graciela Mirales from the World Bank. You have the floor, and now we want to know who has won the prize. Thank you.
Dear colleagues, good evening. On behalf of the co-chairs of the Advocacy Working Group, It's a real pleasure to welcome you to the award ceremony for the 11th edition of the Advocacy Contest. It remains a privilege for the Italian Competition Authority to work in partnership with the World Bank Group on this excellent initiative, which has grown stronger and stronger over the years. The contest stands as a fine example of international cooperation, grounded in shared values and mutual commitment to promoting effective competition. Since its inception, the Italian Competition Authority has supported this initiative with enthusiasm, recognizing it as an innovative, engaging platform for highlighting outstanding advocacy efforts across the globe. Thanks to its inclusive and accessible format, the contest continues to shine a light on the important work of younger competition authorities, many of which don't yet have a strong presence in international fora such as the ICN. Remarkably, this year's contest has also attracted the attention of a governmental department and a think tank. The contest is also a forum for exchanging ideas and experiences, inspiring new projects, encouraging creativity in the field of competition advocacy. A key reason for the contest's continued relevance is the careful choice of themes. The year's edition addresses advocacy to favor supply chain resiliency, the importance of competitive neutrality in public policy and competitive bidding rules, as well as the development of innovative approaches for engaging stakeholders. On behalf of the co-chairs of the Advocacy Working Group, I would like to extend our warmest congratulations to all the winners and honorable mention of this year's contest, and a sincere thank you to all those who submitted entries. Your stories, your commitment, and your passion are what make this initiative such a success. And now, I would like to give the floor to Graciela Mirales, Senior Economist of the World Bank Group.
Thank you so much. Grazie. Well, my colleagues already said so much. I will just repeat that on behalf of the World Bank, it's wonderful to be in this 12th edition, as President Moon said before, the 11th edition that we do together. In the last 12 years, we have received an impressive amount of entries, 408 entries from 75 different jurisdictions, showing that the global reach and the sustained commitment of competition authorities and institutions to advocacy is absolutely incredible. Among them, I want to mention today those authorities that have been most awarded throughout the years. And these are Mexico, Portugal, Spain, Egypt, Hong Kong, and the United States, who consistently have set very high standards in advocacy. This year alone, I want to share that we have received a record-breaking 61 entries covering essential sectors such as food, education, health, agriculture, and energy. We were also pleased to welcome submissions from 4 new economies participating for the very first time in this advocacy contest. And it's exciting to see that the contest continues to grow and to evolve after more than a decade. What truly makes this initiative special, as we will see today, is the concrete and measurable impact that advocacy can generate. Across past editions, we have seen authorities deliver major benefits. I have many examples of this here, but I will only mention our host, the United Kingdom, that were awarded in 2018 with reforms in higher education that yield estimated benefits to consumers of £25 million. This year, we are excited to reveal the enormous impacts achieved by the winning initiatives, but, as my colleague, let me extend the heartfelt congratulations to all of the winners and honorable mentions, and of course, thanks to all of those who share your advocacy stories. So I will start with category 1, that, as President Moon have said, the theme was supporting resilient and competitive value chains to enable private investment jobs and consumer welfare. And the winners are several, because we have wonderful stories in category 1, so beware. The Egyptian Competition Authority is one of the winners, together with the Georgian Competition and Consumer Agency. A joint honorable mention goes to COMESA Competition Commission, together with the Kenya Competition Authority, and we have another honorable mention for the South African Competition Commission. Now let me share what all these stories are about. Egypt Competition Authority worked to target anti-competitive practices in the education sector, projected to save households nearly $1 billion. So, welcome to the podium, Mahmoud Momtaz, Chairman of the Egyptian Competition Authority. Congratulations, Mahmoud. Georgia's Competition Authority tackled high prices in competition in the pharmaceutical market with reforms that cut medicine prices by up to 45%. Please welcome to the podium Irakli Lekvinadze, Chairman of the Georgian Competition and Consumer Agency. Irakli? The COMESA Competition Commission and the Kenya Competition Authority undertook initiatives to tackle inefficiencies and high prices in agriculture and food markets. Please welcome to the podium Willard Mbemba, CEO of the Competition Commission of COMESA, and David Kikemei, Director General of the Kenya Competition Authority. This award is joint. Finally, the South African Competition Commission conducted an ex-post assessment of agricultural development funds established as merger remedies and found that the funds supported 1,000 beneficiaries and created 8,000 jobs. Please welcome to the stage Doris Shepe, Commissioner of the South African Competition Commission. Congratulations, Doris. Now, for category 2, we have a single winner. The topic was embedding competition principles in policies to manage state assets, SOEs, privatization, and public-private partnerships. And the winner is Paraguay, where the Comisión Nacional de Competencia, CONACOM, successfully advocated for the RIP of a fuel subsidy granted to the state-owned oil company. Please welcome to the stage Eduardo González Martínez, President of CONACOM. Enhorabuena.
And now for the team 3, enhancing public procurement and curbing bid reading for government savings. The winner are the Competition Authority of Georgia, Mexico, and Philippines. The honorable mention goes to the Korea Fair Trade Commission. Georgia's Competition Authority broke up systemic bid reading in tenders for free canteen services, protecting public funds, and improving vital support for vulnerable citizens. Please welcome to the podium Irakli Leviknadze, Chairman of the Georgia Competition and Consumer Agency. An ex-post assessment has shown that COFECE's action against big reading in public health procurement led to significant price reduction in Mexico, improving access to quality services for millions, especially the most vulnerable. Please welcome to the podium Andrea Marvan-Saltiel, Chair of COFECE.
Should we take over here? Oh, you switch.
We switch.
The Philippines Competition Commission has implemented an effective strategy to fight bid rigging by developing a tool for proactive detection using all existing data, building partnership with the government department, and raising awareness among businesses. Please welcome to the podium Michael Aguinaldo, Chairperson of Philippine Competition Commission. By expanding its monitoring system to over 700 institutions with daily updates, the Korea Fair Trade Commission has supported bid rigging detection and deterrence, while enhancing transparency and trust in public procurement to the benefit of contracting entities and public finance. Please welcome to the podium Bui-Gun Han, Secretary General for Investigation, Korea Fair Trade Commission. Finally, for the last category, advancing competition through public-private dialogue, the winner is the Secretariat of Economic Reform of Brazil, Ministry of Finance, and Spain National Commission on Market and Competition. The honorable mention goes to Dixie Group, a Ukraine think tank. Brazil's Ministry of Finance have launched an innovative initiative inviting stakeholders to flag potentially anti-competitive regulation. By creating a structured review process, the Ministry now proactively identifies and addresses regulatory barriers, promoting a more open and competitive market. Please welcome to the podium Gustavo Henrique Ferreira, the Undersecretary of Economic Monitoring and Regulation of Brazil's Ministry of Finance. Our 2 decades, Spain's national consumer and market competition has actively supported the liberalization of the passenger rail sector, providing guidance and analysis that helped deliver lower prices, better service, and greater consumer benefits. Please welcome to the podium Cani Fernandez, chairwoman of CNMCC. Finally, through its energy, through its energy transparency index, Ukraine think tank Dixie Group has promoted clearer information for consumers and stronger competition in energy markets. Collaboration with major oil companies help boost transparency significantly, make it a model now recognized in the country's United Nations committee. Congratulations to Dixie Group. Dear colleagues, the ceremony is over. Thank you very much for your attention. Now, a photo of every people. Come on. Andreas, please.